All persons having business before the Honorable Associate Judges, now presiding of the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and this honorable court. This honorable court's now in session. Please come to order.
Thank you. Good morning.
Good
We have 3 cases on the calendar this morning. I apologize to counsel here and counsel in our forthcoming cases for the delay that we encountered. Hopefully everything will go smoothly now. The first case on the calendar, which I will now call, is Alfred Gibson versus United States. Counsel, you may proceed.
Thank you, Your Honor. Good morning, everybody. May it please the court, my name is Russell Bykoff. If I may, I'd like to reserve 3 minutes for rebuttal. I plan to address a fatal weakness in count 2, in proof of count 2 in the government's case, and then move on to the question of whether counts 1 and 2 merge. So I'll just observe this is a fairly simple set of facts, but the issues, at least to me, have become at times mind-bogglingly complicated, in part because it once again could require this court to address the interplay between the general sexual offenses of the ASAA and the victim-specific offenses where the victim is a minor or a child. So with that said, I'll plunge right in. The count 2 conviction is a misdemeanor sexual abuse of a minor, and I'll try to refer to that as MSM or sometimes MSA, misdemeanor sexual abuse, M for minor. The trial judge failed to consider, despite all her many pages of findings and legal conclusions, she failed to consider some basic elements of the crime and failed to reach a legal conclusion about a critical element of MSA minor or MSN, and that is whether Mr. Gibson touched AG, the youngsters or the minors, bare skin close to her genitalia. So I'm going to let you go.
I'm sorry, Mr. Bykoff, you said touched bare skin.
Touch bare skin.
Is that required for sexually suggestive conduct?
It is in this case, Your Honor, because the government made an election with their charging document and then with their proof at trial.
Okay.
So
I mean, regardless of the findings, I thought that we were here on a sufficiency challenge, and I see evidence in the testimony that the complainant is wearing shorts and that your client touches her on her inner thigh closer to her groin area. So why is that not sexually suggestive conduct under DC Code 22-3010-01B2?
well, it's not, because the judge failed to make sufficient factual findings and failed to reach a legal conclusion that it was close to the genitalia.
Well, wait, you're talking about factual findings, but I thought you were making a sufficiency challenge. So are you also challenging the court's factual? So my question goes to sufficiency.
Okay.
And if there's testimony in the record that the complainant is wearing shorts and that your client touches her on her inner thigh, above the knee, you know, closer to the groin area than to the knee. So if you bisect someone's thigh and you have, you know, the midpoint of the thigh and then it's above that, closer to the groin area, why is that not sufficient evidence under 22-30-10-01B2.
Well, that's right, Your Honor. Her testimony was that the touching of the inner thigh, and I think one of the few things that the government and the appellant agree on is that there was a glancing touching with the fingertips on the inner thigh.
Well, wait a
But
second. I mean, again, going back to the testimony, there's more than one touch, right? I mean, there are multiple,
No.
there's a touch of the leg, and then there's a touch of the face, and then there's another, there was initial glancing touch, then there's a touch of the face, then there's a more grasping touch. There's more than one touch of the leg, and the touch that was closer to the groin area is the last in the sequence. And so that's the touch that I'm referring to. That is above the knee, above the midpoint of the thigh, closer to the groin area.
Well, you're absolutely
I
right.
think that's what the testimony reflects.
You're right, absolutely right, Your Honor. The testimony was that there was a second touching, and this, by the way, was the only touching that counted according to the judge, the second touching. This is the one where the victim testified she moved her leg away, and the defendant, Mr. Gibson, was unable to grab her leg, but she was wearing shorts, and the tips of his fingers touched her inner thigh beyond the midpoint between her knee and her hip. So she mentions her hip, and she mentions her groin, but nobody mentions the genitalia. And the statute requires that the touching be close to, quote, 2 words, close to, close quote, the genitalia.
And how can something be close to the groin and not close to genitalia?
Well, there's a difference, I think. And this may be beyond my scope as a lawyer. I'm not a medical expert or an expert in physiology, but the genitalia is one thing, and that's what that's the word the statute uses, and the statute says close to the genitalia. But the trial was all about the hip and the groin and the knee and the inner thigh. So at least on this count,
yeah, I mean,
I don't see it.
The groin and genitalia tend to exist in roughly the same space, counsel. And I don't know why we would hold a trial court to invoking magic words when she said quite clearly, these are her findings, since you're taking issue with her findings. At some point, he puts his hand again on her thigh with his fingers landing on the inner side of her thigh, closest to what would be called the groin area, based on the testimony in this case. You know, maybe the trial judge is just peckish about using the word genitalia in her ruling, but I don't recall an objection to in the trial court that wasn't enough, permitting the trial court to clarify that what she meant when she said the groin area was consistent with genitalia, which seems like a fair reading.
The statute, Your Honor, uses genitalia. The statute doesn't use groin. The statute doesn't use hip. And I'm going to read the judge's conclusions of law in their entirety for this count.
Well, can I ask
conviction.
you, I'm sorry, if we're going to get all technical about terminology, if you had a very self-aware young woman who said, he touched me 2 inches from my vulva, you would say that is insufficient evidence to say he touched her close to her genitalia?
I would say that close to, in the words of the statute, is clearly a judgment call.
No, we're not. I think at this point, we're not talking about the close to, we're talking about the genitalia. And you're taking issue with the fact that the judge didn't use the word genitalia. And Judge Deal then asked you about groin and said, isn't that essentially synonymous, right? Might be slightly broader, you know, to include the back and the front, I don't know. But if you have a very, you know, educated, self-aware about her body complainant who uses biologically correct terms, more precise, and says, he touched me X distance, which is close to my vulva, would you say because she used that biological term that that doesn't count as genitalia? I'm not quite sure I understand what your argument is.
I would not say that. I would say that if had she testified and mentioned a vulva, we know from biology that that's part of the genitalia. That's not an issue. But
Okay, so
I'm
if
not
she-
aware that.
If she testifies that he touched me on my upper inner thigh, we all know what's above the upper inner thigh. Why does she have to use the word? Why does the court have to use the word? Why can't we just say that is close to genitalia?
Well, because that's not what the statute says. The statute gives the option to the government of manifold ways of proving a case like this. And in this case, let me turn to 223010 for a minute, so we can see all the many ways. And the government elected in its information that Mr. Gibson, being 18 years or older and being in a significant relationship, which is also an important statutory term, siblings related by blood, with AG, a minor under 18 years, which is another issue, that is 17 years old, engaged in sexually suggestive conduct, that is, with a minor, that is contact between Mr. Gibson's hand and AG's inner thigh, which was intended to cause and reasonably did cause sexual arousal and sexual gratification. So the government, in its information, charges a touching from Mr. Gibson's hand with AG's inner thigh. And the statute then says that in subsection B2, touching a minor inside or outside his or her clothing, close to the genitalia and several other body parts in that area. So the government was trying to show a touching on the inner thigh, but the statute has a specificity of close to the genitalia. And
Mr. Beckhoff, may I ask you a question about this?
yes, Your Honor.
Do you agree that the misdemeanor sexual abuse of a minor statute is a lesser included offense of the second degree sexual abuse of a minor statute?
Your Honor, I think that may be from one of the cases. Fortunately for me, that crime was not charged in this case. We only have.
Well, but you see, what I'm wondering is this, when you say that crime wasn't charged in that case, that crime involves sexual contact rather than the specific sexual touchings in the misdemeanor statute. And touching the victim here on her inner thigh would have been sexual contact. Do you agree with that? It falls within the definition of sexual contact.
Yes, under the first count,
So-
misdemeanor sexual abuse.
So it would have been, so the evidence here would have been sufficient to convict Mr. Gibson, not simply of the misdemeanor, but of second degree sexual abuse of a minor, a felony. It seems odd to think that the conduct proven would have been sufficient to convict him of the greater offense, the felony, but not sufficient to convict him of what seems like a lesser, perhaps lesser included, offense of misdemeanor.
Well, Your Honor, I didn't look carefully into the felony and the felony elements because that's not part of this case. But I will argue that, speaking of lesser included offenses, in this case, as charged and as proved, that count one, misdemeanor sexual abuse, MSA, is a lesser included of MSM, misdemeanor sexual abuse of a minor. And
Is
therefore,
that true? Is it true that you can't commit misdemeanor sexual abuse of a minor without committing misdemeanor sexual abuse? I'm not sure that's right.
I think it is right in the context of this case, Your Honor, and it depends what we're looking at. And we want to compare apples and apples and not apples to oranges. I think what the analysis under
Just,
block.
can I ask an example? If somebody, if he had put her back, his hand on her waistline, close to the buttocks under 3010.01B2, that would not satisfy misdemeanor sexual assault because he didn't touch an enumerated body part. He was close to it, which is allowed under 3010, but not under misdemeanor sexual assault, I believe. So why isn't that preclude a merger? That you can commit the misdemeanor sexual abuse of a minor without committing misdemeanor sexual assault by being close to a body part that would not satisfy misdemeanor sexual assault.
Well, but in this case, it was charged with the touching of the inner thigh, which is a misdemeanor sexual assault, and it was proved. So we have
Is that how we do a Blockberger analysis for merger purposes?
Well, I think
don't we look at the elements of the crime instead of the facts of the particular case, right? And you can think of all sorts of different factual scenarios along the lines that Judge Deal just mentioned. You know, if someone touches me or a child on their collarbone, right? Maybe that's close to the breast, but that is not touching the breast. So it's not misdemeanor sexual abuse, but it could be misdemeanor sexual abuse of a minor. You can play out with the close to language, you can play out all sorts of different scenarios, but you have to look at the statutory language, not the actual facts to do the Blockberger analysis, no?
right. Under Blockberger, we look to the elements, but what elements are we comparing given the manifold ways in which both of these crimes can be committed under the statute? There are many, looking at the statute, there are many different options that can exist. In common sense, Your Honor.
Well, how narrow do you want us to go, right? I mean, I would think that we would at least look at, compare what constitutes sexually suggestive conduct with what constitutes sexual contact, right? But what narrower frame do you want to apply to the statutory analysis?
I would start with what the elements are in the government's charging documents, and then look at what the elements were that the government attempted to prove at trial. And in this case, we can line up the elements of these two misdemeanor crimes, the one that's not victim specific, MSA, which is 22/3006, and we see that has a sexual act or sexual contact. And then the next element would be knowledge or reason to know that the act is without permission. And then the third element would be an intent to arouse or gratify the sexual desire of the victim or the defendant. Then the second statute, MSA minor, which is 22-3010.01, is sexually suggestive conduct with a minor under the age 18, which in pertinent part includes touching outside the minor's clothing close to the genitalia. And I would suggest that that element and the first element that I mentioned in the other statute, sexual act or sexual contact, are essentially the same as charged and proved in this case. In fact, the government is getting literally getting double duty out of the single touching that Mr. Gibson committed against AG's inner thigh. That one touching is the evidence.
You're making an argument that sounded pretty good before Blockberger. I mean,
before Blockberger. Okay.
Transactions, you know, single transaction might have gotten you all the way home pre-Blockberger, but now it just sounds irrelevant to me. from a merger
Well,
analysis.
It is a single transaction, and what we're doing in this case is looking at an attempt, a possibility to convict and punish twice for the same act. And the judge backed away from that because the trial judge noted the possibility of a merger. And the government did ask for consecutive sentences. The judge imposed a 180-day concurrent sentence. So I think basically the first element is going to be the same. The second element is in MSA, simple MSA, knowledge or reason to know the act is without permission, raises a very important issue for this court based on your precedents in Ray MS and Davis of whether that applies at all for a 17 or 16 or 17-year-old minor who's facing, who's been the victim of a simple MSA charge. There may not be, in fact, any requirement to prove that the defendant had knowledge of a lack of permission.
Haven't we held that in the minor specific cases where the other elements are satisfied, the minor's consent is not a defense?
Well, by its very own terms, yes, Your Honor. By its very own terms, MSM and all the victim-specific line of statutes removes consent as a defense, and it removes the elements of knowledge of lack of permission as an element the government has to prove. And you have removed, this court has removed from simple, the non-victim specific statute, misdemeanor sexual abuse, 3001. There is no requirement for children for the government to prove that the defendant was unaware of. In fact, In Re MS says that there's a conclusive presumption that the sexual contact was committed without the minor's permission, without the child's permission. And I think that case and the logic behind it would suggest very strongly to me that it's a very, very short step for this court to say that minors as well do not give their permission, and that there's a conclusive presumption that in the generic MSA statute 3006 that the act was committed without the minor's permission. If you look at it that way and that element is gone, then the two statutes are pretty much the same. The key test, according to In Re MS, is whether Mr. Gibson could commit MSM, the victim specific with the special relationship, without at the same time committing MSA. And on the facts of this case, there's no way he could commit the MSM with his recently discovered sister. She's under 18, he's over 18. There's the intent to sexually gratify or arouse. So he commits 3006 simple MSA in the course of committing MSM under 3010. That's our case.
All right, we will give you a few minutes in rebuttal. Let us hear from counsel for the government. And,
Thank you.
Mr.
Thank you very
Snyder.
much. Thank you very much. Your Honors, good morning. My name is Stephen Snyder, and I represent the United States. On the sufficiency question, the evidence was sufficient to sustain both convictions. The victim testified repeatedly that the defendant, among other things, the appellant, touched her on her inner thigh, as she described, closer to her groin. She gave a physical demonstration for the court, in open court, and the judge, who was in the best opportunity to see this, actually saw her give the demonstration, and then the judge found in several, at least twice, that the appellant touched her on her thigh closer to the groin. Additionally, when the government was arguing on the motion for judgment of acquittal, among other things, with respect to misdemeanor sexual assault of a minor, MSM, the government argued that the appellant touched the victim close to the genitalia. So that was before the judge. And I think based on this, the evidence certainly established that the appellant touched her close to the genitalia. And at trial, the appellant didn't argue anything about whether there's a distinction between the groin or genitalia or anything of the sort. The argument at trial was intent. It wasn't for lack of a better term, the sufficiency of the government's proof. And so as we noted in our brief, appellant can argue, appellant cannot show that the court plainly erred in not giving a more specific description. The defense counsel. Yes,
I'm sorry. I was going to say this issue has not been raised, nor was it raised in our previous misdemeanor sexual abuse of a minor case. But I wonder if you have a view on whether the statutory phrasing close to, be it the genitalia or other parts of the body mentioned in the statute, is sufficiently precise so as not to be unduly vague.
We haven't considered that question. It hasn't been raised, so I don't know whether that broad language is an issue. An appellant hasn't raised a due process challenge here, so I haven't focused on that.
Okay.
But in any event, given the findings of the trial court, and particularly appellant's trial counsel's failure to seek more specific findings under Superior Court Rule of Criminal Procedure 23, namely whether groin or close to the genitalia are close enough or synonymous so as to fall within the ambit of the statute, I don't believe there's any basis for appellant to challenge the sufficiency of the evidence. So if the court has no more questions on sufficiency, I'll move on to the merger question.
I just wanted to make sure I understood what you just said, that
Sure.
there was no challenge to the court's findings. So we shouldn't worry about that, but you're not making an argument, are you, that the sufficiency of the evidence as to the location of the touch is unpreserved? Or are
No.
you? Are you?
No, I'm not making that argument at all.
Okay, thank you.
No. Sure. So with respect to the merger question, as this court and other courts have found repeatedly, the question is whether, bringing it to this case, whether one can commit MSM without committing MSA. And the answer to the question is yes. And the reason is because there are substantively different elements. You certainly have the elements with respect to MSM of a minor in a special relationship, but also in MSM, the government is required to prove that a defendant engaged in sexually suggestive conduct. And that conduct is to sexually arouse himself or others. Whereas in MSA, the government is required to prove that a defendant made sexual contact, and the sexual contact is to abuse, humiliate, harass, degrade, or arouse or gratify the sexual desire of any person. And those are different elements. So it is possible, and the court actually gave a number of examples to commit MSM without committing MSA, such as by touching a victim, with a 17-year-old girl with whom the defendant is in a special relationship, say, on the shoulder, close to, but not on the breast, or touching underneath the sleeve of a shirt, anywhere, touching her forearm under the sleeve of the shirt, assuming the intent elements are met. And so therefore, because, and those acts would not constitute MSA. So therefore, it is possible to commit MSM without committing MSA. Appellant argues, he says, on the facts of this case, they merge. But the courts are clear that you don't look to the facts of the case. We look to the elements, and then, as this court has stated, the practical question of whether it is possible to commit one offense without committing the other offense. And because it is possible to commit MSM, because we have these two different elements, the court is not even required to address the consent issue that appellant raises, which is whether a 17-year-old minor should be considered presumptively unable to grant consent or permission within the ambit of MSA. This court has never addressed that.
And yet the government submitted a 28K letter going to that question. Do you want to speak to that at all?
Well, I submitted the 28K letter because we came across that decision, and the decision which was decided after we filed our briefs, and it did address the consent issue. And so I wanted to appraise the court of its existence. I don't believe the case is dispositive, and in the end, that case does several things. One of which is it leaves open, well, it doesn't address the issue of consent with respect to MSA because that issue wasn't raised. But in the case of simple assault in a nonviolent sexual touching, the Augustine court did find that a minor, in other words, a person above the age of 16 but below the age of 18, consent could be a defense, if my understanding of Augustine is correct, with respect to simple assault. But that court didn't address MSA. So it's a little bit of a long answer. I apologize. Yes,
MSA wasn't charged in that case, am I correct?
That's correct.
Okay.
MSM was charged in the case. And
right.
So that ultimately was the nexus. But that case doesn't compel a different analysis of our current case or a different result in that case. Because again, here, the actus reus between MSA and MSM, actus reus are different. Sexual contact in MSA, sexually suggestive conduct in MSM. And those two offenses also have different mens rea elements. And so therefore, because you can commit MSM without committing MSA, MSA does not merge into MSM, and the court's not even required to address the consent question. If the court has no more questions, the United States asks that the judgment of the Superior Court be affirmed. Thank you.
Okay. Thank you. Mr. Beckhoff, a few minutes.
Well, thank you, Your Honor. I'd like to just come back, if I may, to the interplay between the two arguments I was making without going into such detail again. My arguments on the existence of a merger with MSA being a lesser included offense of MSM in this case is in the alternative. So the court, should the court agree with our first argument that the judge failed to find that the touching of the inner thigh was close to the genitalia, then if the court agrees with us there, then there's no need to consider the merger because the count one or count two would be dismissed as based on insufficient evidence. Let me, because it came up, let me just give citations to the record should the panel wish to examine the testimony by the victim, AG, in this case. We describe that evidence on page 6 of appellant's brief, including footnote 5. And then I direct the court's attention to the first day's testimony, December 13th, pages 63, and then pages 65 through 67, the testimony of AG about my client's effort to grab her leg while sitting next to her when he momentarily touches her inner thigh with his fingertips between her knee and her hip, but closer to her hip. Pages 68 and 69 of that same transcript, December 13th, involve the AG again describing that conduct. Cross-examination was on the second day of testimony, December 17th. Pages 10 to 15 include the demonstration by AG of the touching, and the judge observes it's the upper part of the inside of her thigh, and neither attorney object to that. Then the judge reaches her conclusions of law on count 2, MSM, on pages 41 to 42 of the second day of the testimony, December 17th. The judge says, with respect to count 2, misdemeanor sexual abuse, I do find, and that would be count 2 is MSM. It's not exactly, it's not misdemeanor sexual abuse. That's a bit confusing. The judge says, I do find that, again, Mr. Gibson touched AG's thigh when they were sitting on the couch, and he touched the top of her leg, again, her bare leg, with his hand really, in the context of saying she was a beautiful effing girl or woman, although constantly referred to her as well as his baby sister or periodically did so. And I do, quote, continues, and I do find that he did so, a 40-year-old man with an intent to arouse his own sexual desire or based on his sexual desire and to arouse himself sexually. And I do find as to the, so that's the second count of misdemeanor sexual abuse of a minor. And again, the testimony was that Mr. Gibson was more than 40 years old at the time of those acts. So I believe that the sufficiency of count 2 is very much in play on MSM. It was preserved, as Judge Easterly points out. The argument we are making now is that the evidence was insufficient. Close to, as I may have said before, and forgive me, is clearly a judgment call, but the trial judge seemed to be entirely unaware of this requirement, and she simply never addressed it with either a factual finding or a conclusion of law. To find that the evidence was sufficient to sustain conviction on count 2, it seems to me would require that this court speculate about how close Mr. Gibson came to a prohibited body location, or how far away his fingers were from the genitalia. And I'll stop with that if there are no further questions. Yes, Your Honor.
I just want to, I mean, that seems to be a different argument that along the lines of what Judge Glickman was suggesting about the statute being vague, that close to has to be a specific distance from. But, you know, it's hard to square your argument that the court ignored the close to aspect of it when on page 39, the court makes a finding. I think this is the court. Am I looking at yes, this is the court on page 39 says, at some point he puts his hand again on her thigh with his fingers landing on the inner side of her thigh closest to what would be called the groin area based on the testimony in the case. And the testimony in the case is really, I mean, you know, I guess the defense went for it. It was really trying to get her to say on cross-examination that the touch was closer to the knee, and it didn't work. And she said, you know, on page 14, you know, the question was, it's down closer to your knee than to your groin area? No, it's closer to my groin area than my knee. And then she says, can I show you? And the defense is trying to back off, I guess, and says, that's all right, I understand. And then there's a demonstration, and then the court says, based on this court's observation, it's the upper part of the inside of her thigh, and no one objects. So it seems like there is a specific finding about the location, and it is based on the testimony. And to the extent that your argument is it has to be close to, has to be a quantifiable distance, that just hasn't been briefed for us.
No, and I'm not saying that it is. I'm conceding, Your Honor, that close to is a judgment call, but the trial judge never made that judgment, whether it was close to the genitalia, because she was focused on touching the inner thigh. And she did focus on, or there was testimony about, as we've said, being closer to the hip or the groin, but no one really focused on the statutory element that the government relied on under the MSM statute to prove that it was a sexually suggestive conduct. And we did not raise a due process argument at trial. We didn't brief it here. But we are focusing on sufficiency and arguing that it was insufficient evidence.
Thank you.
Thank you very much, Your Honors.
Counsel, thank you both. You are excused and you may log off.
Thank you.
Okay, we got some people. Got the judges. Okay,
Good morning.
good morning.
We'll call the second case, Ruth Saunders versus Stephen Hudgens et al. Mr. Leslie, you may proceed.
Little challenge here, Judge. I'm gonna make sure I got the right thing. My name is Michael Lasley. I'm the appellant on behalf of Ruth Saunders. And I was asked to reserve at least 3 to 5 minutes in rebuttal. The first point I wanted to make in this appeal is that Judge Pan did not follow the mandate in this court to allow Ruth Saunders to consider the specific performance by she did not review the circumstances of the committed reversible error in terms of the fairly consideration of the pleadings that she made in this matter, and also in reference to the conduct and conspiracy and tortures conduct of Mr. Arnold, and as well as the circumstances of the interference and the jury verdict and the order and memorandum of Judge Macaluso in determining whether Ruth Saunders was entitled to specific performance. Rather, Judge Pan would adopted the arguments of the appellee, Mr. Arnold, that pretty much concluded, Your Honors, that it challenged the actual rulings of and verdict of the jury by claiming that the contract was not valid, which is the thing that Judge Macaluso found with the verdict and findings of the jury.
I don't know if that's true, counsel. There are two different questions in my mind. One is, was there a contract for purposes of tortious interference of contract, for breach of contract? Then there's a separate question for specific performance of whether or not its terms are sufficiently definitive to, order that they be carried out. And here we have cases that say, those two things, you can have a contract for purposes of enforcing a breach of contract claim, a tortious interference claim, that could still be not definitive enough on its terms to order specific performance. I can cite a few if you want, but do you have any reaction to that?
Yes, I do, Your Honor. The main thing is you cannot, in the context of saying she was not ready and able to perform the terms of the contract, out of the context of the conspiracy and tortious interference of the contract. So the terms of the contract was somewhat negated by the failure and the conspiracy of Mr. Huggins and Mr. Arnold in terms of what they did to keep her from even trying to fulfill the terms of the contract. So what's relevant in this context is that you cannot argue that she was not able to fulfill the terms of the contract, or she was unable to dictate to Mr. Huggins what she was trying to achieve by the whole focus of what the contract was supposed to say and do. So the case law focuses on the fact that you cannot negate a contract, you cannot negate the circumstance of a contract by the conduct of the one of the parties, and in this case, Mr. Huggins and then Mr. Arnold. So the notion that the contract was not, the terms of the contract was not fulfilled was negated by the fact that the contracts were undermined by their conduct and conspiracy. And what the
let me just separate out 2 points again.
Okay.
One point is your client didn't fulfill the terms of the contract in the past. That's one thing. And I agree with you that if, the other side breached, that can't be held against you. There's another question of, for purposes of ordering specific performance, have you and your client demonstrated that you are ready now to proceed with the terms of the sale, to cover the first mortgage, to pay the money? Have you secured those funds? That's a separate question. It's a separate question that I read the trial court to be saying, no, you have not demonstrated that you're ready, willing, and able to go forward with specific performance. And I haven't seen a response to that in your briefing. And so do you have one?
Well, yes, we do.
Basically, it's that you haven't lined up your ducks. You haven't lined up your ducks in a row to carry this.
The point is, the ability to line up the ducks in a row is based on the fact that with the negation of the contract itself by the appellant, lawyer.
Why? No, counsel. I mean, hear me out for a second.
Okay.
When it goes back, we went back before the trial court to consider whether or not she would order specific performance. You could have said, Judge, look here, we have secured financing. We have those funds available. We are ready to close on this contract tomorrow. If only you would order that. But I don't see anything like that in the record that suggests you guys are ready we're ready for specific performance.
With all due respect, Your Honor, the whole concept of us not being ready and willing was the argument of the appellee. The point is that you can't argue against the contract, and that's what that was their whole discussion, was that the contract was not valid. You can't negate what the jury did. The jury heard the evidence. The jury knew what the conspiracy and the tortious conduct of Mr. Arnold and Mr. Huggins. You can't argue that the terms of the contract was not met, whether my client was ready and willing. And she did indicate she was ready and willing, but that was again negated by Mr. Huggins' lawyer that said he wouldn't even meet with her. So, and as well as the fire that happened. So I'm saying we cannot argue that that's relevant in the context of what they did. Now, if there was no conspiracy, there was no tortious conduct, that I would agree with the court that would be an issue of whether we're ready, willing, and able. But the Judge Pan didn't even look at that. She didn't even focus on that. There was a technical problems I was having with the pleadings. She never even argued whether or not that was relevant. She argued that the contract was not relevant, but that's not in the context of what was really happening. And you can't negate what the jury did. The jury was looking at the same rules, the same facts. The judge concluded, Judge Macaluso concluded that was a valid contract. We cannot come back and argue the contract was not valid because of the terms when she argued that the contract was, and the jury found that it was. Now, it'd be different if those elements was not there. It would be different if it wasn't the tort and the conspiracy. Or the issue with Judge Pan would have been that would you be able to perform the contract? We never got an opportunity to even do that. But based on what she had concluded was what was that issue, was whether the contract, and I think that's different from what the jury did, what Judge Macaluso said. She can't argue later that the contract was not valid, or we didn't have all the terms, because that's kind of negate what the jury was doing and what Judge Macaluso doing. All these people for years had looked at what was going on in terms of the terms of the contract, and my client had tried to deal with the contract. It was a farce. She's been paid Mr. Huggins' monies. He decided through the conspiracy that he wanted to get more money. It's a greed thing there. And he wanted to go with Mr. Arnold went along with. And it was based on that they were able to conclude that we would go forward and sell the property to Arnold, and notwithstanding the terms. So they weren't even concerned about the terms because they was engaged in a conspiracy. So what our position, Your Honor, is that the whole point is you cannot look behind what the Judge Macaluso did. You cannot go behind with the verdict of the jury. The jury saw all the facts. The jury made the determination of what was going on. Now, when you say, will we be able to, which Judge Pan never dealt with, and never even discussed, whether or not we would be ready, willing to deal with the contract.
Counsel, let me try an example. Let's say I agree to sell you a car in 2010. Let's call it a 1994 Buick Skylark. So I'm selling you a car in 2010, and I breached, and I decided to sell it to somebody else, causing you some damages. And 5 years later, you win a jury verdict saying, yes, I've damaged you. The car was a great deal. It cost you $5,000. And then there's a question of whether or not the trial court judge can order specific performance. One reason why the judge might not be able to is I don't have the car anymore. I've sold it to somebody else. Another reason, let's say it exploded. That car doesn't exist anymore. So the question of whether or not specific performance can be ordered because the parties are willing, capable, and able to carry out the envisioned performance is separate from whether or not they have a contract. And I still don't hear you answering that question, especially where Ms. Hudgens was not even a party to this suit at the time Judge Pan ruled. So how could she order her to carry out specific performance?
Well, Huggins was part of the suit in the second bifurcated case. He was part of the suit. Judge Pan argued that he was not part of the suit. He testified in the case. He was willing, in terms of the TOPA issues that the TOPA plaintiffs argued. So she never argued and never concluded. That was one of the issues that we had. She never concluded that the terms of the contract was not valid. She just arbitrarily said that based on adopting the terms that the appellee argued, which argued their whole pleadings was that the contract was not valid. And you can't go with the jury and everything else is saying that the contract is not valid because that's the terms you want to argue, when that's, as I said before, in total contrast of what the jury and with Judge. In other words, you're trying to say that you would have to conclude that the jury and Judge Macaluso was wrong, but the contract was valid. If it's valid, then you can't then go back to the fact it was valid because of the term. Specific performance, and the other side of that is Ruth Saunders has a right to some kind of remedy, and that's why I think this court has sent it back to the trial judge to fashion whether or not she can determine whether she is entitled to specific performance based on the fact of what had happened to her. And it cannot be from the point of view of the other side claiming that the whole question of a valid and a terms is different, because that's a different look and a different focus on the question of specific performance. Specific performance cannot be negated or controlled contrary to what the jury and the trial judge is saying.
Mr. Lastly,
Yes, sir.
let's accept for a moment, let's accept the jury verdict that the contract was valid. I just want to be sure I understand something. Did the contract, do I understand correctly, that the contract required Ms. Saunders to essentially do four things, or to do at least four things? It required her to assume the first, or to be willing to assume the first mortgage. Is that right?
Yeah, yes, I think that's part of the contract.
And is it right that it required her to be able and willing to pay the full second mortgage?
Which she did.
She did do that? She paid that?
Yes, she did. She paid his and this was during the time of the fire, when Mr. Huggins had asked her to pay money and to help in terms of the rehab of the building. What she did was continue to pay his mortgage and continue to pay
Did she
him at
pay,
least.
did she present evidence? The
Huh?
mortgage,
I'm
the
sorry.
second mortgage had not been paid in full, had it?
No, because that's when Mr. Huggins sold the property to Mr. Arnold.
Okay, so if I understand correctly, I just want to be sure I have the
Yeah.
facts here.
Right.
The contract required her to pay in full the second mortgage in order to acquire the property. And am I correct that it also, and the second mortgage as of yet has not been paid in full, I think. Did the contract also require her, another condition was to pay the water bill, is that right?
She
I think
paid
that's
the
what
water
you
bill.
alluded to. And to pay Hudgens and his attorneys, is that right?
Yes, and she made efforts to do that, and because Mr.
Well,
Huggins.
the question in my mind is different. For those four
Okay.
things, at the time of trial before Judge Pan, those four things had yet to be completed. She may have started on them, but they had yet to be completed. Did she present evidence that she was ready, willing, and able to do those four things completely and fully?
Yes, she was willing. Yes, what she said, and what I'm saying.
What was that evidence?
Your Honor, what she said, and what the whole issue in the case was, Judge Pan adopted the argument, mistakenly argument, that she didn't file the appropriate pleadings.
Well, I'm not asking about that. I understand that you object to Judge Pan's ruling there, but in the alternative, she said, even if I get to the merits, you would not prevail. And I just want to understand, are you claiming there was evidence in the record before Judge Pan that Ms. Saunders was at that time ready, willing, and able to assume the first mortgage, pay off in full the second mortgage, pay off in full the water bill, and pay Mr. Hudgens and his attorneys? I don't know what that money amounts to.
Yeah, she was willing to do that.
You
The
say that.
point-
What I'd like to know is, what was the evidence in the record that she was ready, willing, and able to do those things? Not just
Well-
willing, but ready and able to do them.
Well, the point is, Your Honor, is that the question is out of context of what was going on. What Miss Saunders was attempting to do was to receive Pacific Performance, but the point is, when she made an
I
effort.
mean, I would think what she's got to do is she's got to come into court and say, I either have the cash in hand because I have a big bank account, or I've got the financing, here it is. Or,
She filed
and I'd like to
pleadings
know if she
before.
put in that kind of evidence.
Well, there was evidence in the case. None of those evidence even got to Judge Pan. But I'm saying before that, and Judge Macaluso, and the pleadings in the cases and the stuff we had filed, she had made efforts and obtained loans and sent a letter to Huggins, letter to his lawyer, for that lawyer, for her to pay the $30,000. And that's in addition to the $10,000 she paid in the interim period. And Mr. Huggins had agreed to that before he decided to sell the property to Mr. Arnold. So,
Mr. Grassley?
Yes, ma'am.
There was a conversation at the hearing, in 2018, it's in the joint appendix, around 600, just around there, where the court is asking actually if she's limited to the record from the trial, right? And what was your response to that? Because it
I'm
seems
sorry,
like
I didn't understand that.
So, as far as I can understand, it sounds like appellee's counsel was arguing to Judge Pan that the issue of specific performance had been fully litigated at trial, and the court just hadn't made findings on that. And so Judge Pan specifically asked you to respond to whether I'm confined to the record before Judge Macaluso or whether additional evidence can be presented. That's it. That's at page supplemental appendix 602. What was your, did you argue, yes, I should be able to present specific evidence and here it is?
Well,
Or did
yes,
you
I
agree?
argued, that was at her hearing. I did argue that she is bound by the decisions of the jury and Judge Macaluso. And
But sorry, let me make, again, making this distinction that Judge Deal was making between evidence that there was a contract, right?
yes, ma'am.
And evidence that shows that your client is ready, willing, and able to perform the terms of the contract. And it sounds like what Appellee's counsel was arguing before Judge Pan is all of that evidence was presented at trial. You shouldn't look at what the current circumstances are.
Well, the circumstances did not change. The circumstances were the same as what the verdict and what Judge Macaluso argued.
That might be true. That might be true as a matter of fact, but I'm wondering whether there needed to be some proof of that, right? I mean, your ability to make a down payment, to have financing, right? I mean, banks don't extend offers to pay mortgages for an unlimited amount of time, right? They usually say, here, we'll finance you at this rate and you have to close within this period of time. So the fact that she was ready, willing, and able to perform at the time of trial might not be dispositive of her ability to perform at the time you're back in front of Judge Pan.
Well,
right?
we were initially, and what we thought, the appellant thought, that we were there to see what, in fact, would be decided in reference to what was happening in the jury case and what the Judge Macaluso ruled. I don't think there's any issue at all in reference to what may have happened to their arguments. I don't think that at all follows anything.
Okay,
So
let us hear. I'm sorry, I didn't mean to cut you off.
No, go ahead.
Okay, well, we'll give you a few minutes in rebuttal. Let us hear from counsel for the appellees.
All right, thank you.
And let me ask, I gather are there two appellees before us now?
That's right, Your Honor.
And have you discussed among yourselves how you want to divide up your time?
I'll take the first 10 minutes, Your Honor, and Ms. Alexander will take the second 5.
Very good, thank you. Okay, Mr. Russo, go ahead.
May it please the court, Michael Russo on behalf of Defendant Arnold. There are two aspects of this brief appeal that need to be addressed. The substantive issues were addressed on Mr. Lashley's argument. I do want to just touch or raise the fact that procedurally, this case, it puts us at a distinct disadvantage in that the brief is devoid of any of the formalities, but most importantly, devoid of citation to the record. There are 2 paragraphs in Mr. Lashley's brief that refer to a record or any evidence. Those are paragraphs 20 and 21. And it should be noted that those paragraphs refer to the brief that Mr. Lashley submitted to Judge Pan that Judge Pan rejected. But
are you sure this is where you want to start your argument, that his brief is devoid of citations to the record?
What I do want to point out is that the record that is cited is not the record before the court. It's a deposition.
I appreciate that, and that is very much intertwined with the first issue with the first argument that he makes, which I take to be, on October 16th, he filed a brief with the trial court, and clearly had some technical issues, and for the trial court then to strike it and not consider it seems a bit draconian. Everybody seemed to have it. It's in the record. The trial court had it. I think it was electronically filed, or at least it went through the case file express. So I'm not sure what happened, but it seems pretty severe to me, to his client, that if he had technical issues that precluded him from understanding that his brief hadn't been filed, that you're going to end up dismissing a obviously meritorious, a case that at one point had won a jury trial.
Judge, the sole point I'm trying to make is that the only citation in the appellant's presentation to this court is not a citation to the record. It's a citation to a deposition that was
Right,
not
and-
offered as part of the record.
Counsel, did you move to strike his brief?
The court did that sua sponte. Oh, yes, we moved, in this
No,
case.
in this
dismiss
court,
the-
right? I mean, it seems we're here.
Okay,
And the brief is here and it seems water under the bridge. So could we go back to where I was with Mr. Lasley during his argument? You know, at least at this point in the transcript, it's supplemental appendix 605. The court says that she thinks that she should only look at the record that was before Judge Macaluso and not look at any new evidence as far as specific performance.
I think that was this court's mandate on remand. The court.
So you think it was correct for Judge Pan to say, I shouldn't consider whether Mr. Lasley's client has the current ability to specifically perform. I just should look to see whether there was evidence at the trial that established that she could specifically perform. And if so, then she could elect between the damages and the specific performance. But her current ability to specifically perform was legally irrelevant. Do you think that that's correct?
I believe it is contrary to the court's mandate. I do believe the court instructed Judge Pan to consider evidence previously submitted.
What did you argue before Judge Pan? Did you say, hey, we want to know whether she can specifically perform right now?
No, we argued the record before Judge Pan.
And what
And
did
there
you
was no
argue? What did you
offer.
argue in your brief on appeal to us?
We argued on our brief to appeal that there was no certain contract, and that she wasn't ready, willing, and able to perform at any point prior to the trial.
But what about right now? You don't think
Did not argue that issue.
Isn't that the relevant question for specific performance? Going back to my Buick Skylark example, whether or not I was ready, willing, able to perform at the time of the breach, or the other party was, seems totally irrelevant to whether or not you can order specific performance, which would seem to hinge on whether or not they could perform it now if ordered. Doesn't that seem like what we consider and what the trial court should have considered when deciding whether or not to order specific performance?
Well, if that is the case, there was no attempt to offer testimony to the court at Judge Pan when Judge Pan was arguing.
Well, I think what Judge Easterly is saying that you cut it off at the legs. That Judge Pan cut it off at the legs because she said, I'm limited to looking at the pre-trial evidence, which seems plainly wrong to me. Now, Mr. Lasley doesn't raise this point, but I think it's pretty clearly wrong. And I don't know why a trial court, when deciding whether or not to order specific performance, would preoccupy themselves with a time in the past as opposed to their present ability to perform. I don't understand why that would be true.
Well, it's an issue that was not preserved for appeal. There was no attempt or request to offer new testimony. The briefs that were filed did not present any new testimony, did not ask to present new testimony to the court. The briefs were presented, parties ultimately appeared for oral argument and argued it.
Whose burden is it to establish? You know who has the burden of establishing the propriety of specific performance?
The burden is on the plaintiff to show that the plaintiff had a certain contract and that they were ready, willing, and able to perform that contract, and ready, willing, and able to perform it within a reasonable period of time. So, and I think Mr. Lastly at the supplemental appendix at 602 was specifically asked whether it was limited to the record, to which he responded, well, what they just presented to you is what they claimed their interpretation of the jury verdict. What was before Judge Macaluso was the jury verdict, as well as her rulings in reference to certain aspects of the defendant's claims. He does not ask to present new testimony. While that may be an argument, it's not one argued by the appellant or preserved on appeal. The evidence that we have is that the contracts that are for which they seek specific performance are not certain, not sufficiently certain.
I want to talk about that for a second. What are the differences between the two contracts aside from the 170,000 and the 153,000 term, which, you know, I feel like when appellant says we're happy to go with the higher price term, you might lose any complaint to the uncertainty of the terms. What else is there? What are the other differences?
Well, the differences are a function of both contracts apparently are offered as attachments to the settlement agreement, and the settlement agreement have alternative terms. But when you boil it down to whether a contract is enforceable for specific performance, you have to know what the terms are that you're going to specifically enforce. It's not for the judge to make those inquiries. And I think this is where Stanford Hotels, which we cited, comes in, and it refers to Judge Lavelle, the Southern District of New York's opinion, where they identify a type 1 contract and a type 2 contract. Type 1 contract is a contract that is complete in all essential terms, subject to negotiation and committal to writing, and negotiating on some of this other details. That contract is specifically enforceable. A type 2 contract is basically a commitment to continue to negotiate essential terms of the contract.
You're saying it was a term sheet. I mean, you basically had an agreement to further hammer out the terms later.
Well, it is a type 2 contract is an enforceable contract. And we argue that that is the contract the jury enforced and entered damages for, because Mr. Arnold was held to have interfered with the ability from that contract to go from an agreement to agree to a final committed agreement. Because of that interference by Mr. Arnold and Mr. Hudgens, our argument is it never became a stage 2 contract, which could.
But my simple question I was asking about the differences between the $170,000 term sheet and $153,000. But let me go more directly at your current position, which is what terms were left to be decided under what you're referring to as a type 2 agreement to further negotiate. What was left outstanding under the contract that the jury found?
How much to pay?
Okay, and when the only options are 170 and 153, and appellant says we're the purchaser, we'll take the higher price, it doesn't seem like you're in much of a position to complain about that. Was there anything else?
As to the certainty of the contract?
Yeah.
No, there's nothing else but the term of that amount. At one point, Ms. Saunders concedes in her trial testimony at SA 298 that she decided not to go forward. This is confirmed in her trial testimony, which wasn't offered, I apologize, as part of the supplemental appendix at 285, 286, the trial pages. She said she wasn't going forward. Then later on, she decided to unilaterally revive her contract to go forward.
And that sounds like an argument you should have made to the jury. I mean, that sounds like a breach.
That is an argument that was made.
It didn't go over so well for you, though, right?
Well, whether
it seems difficult to make that argument now that the Court of Appeals has said we need to figure out whether or not she's entitled to specific performance. I mean, if it were really established that she had abandoned efforts to buy this property, I don't think we would have issued an opinion saying, go and do more work to figure out specific performance.
To determine whether there was a contract in place, and that is the first element of a specific performance evaluation. So I do
Right.
think it is important to the analysis. My time is near. With respect to the conspiracy argument, I'll only say, when specifically asked at SA 667 for Mr. Lastly to cite to evidence or proffer evidence as to why the conspiracy prevented the appellant from actually conducting, from performing the contract, he was not able to cite any specific evidence of that. And when specifically asked to cite evidence of ready, willing, and able, he conceded that she made efforts. That was as far as they went. Your Honor, I cede the rest of my time to Ms. Alexander.
Good morning.
Okay.
Good morning.
Ms. Alexander, go ahead.
Wendy Alexander on behalf of Appellee US Bank. Obviously, most of our position is similar to that of Appellee Mr. Arnold. And, you know, as far as a couple of the points that you've raised as to whether we should be looking at specific performance and her ability, Ms. Saunders' ability to perform now, you know, obviously, again, Judge Pan determined not to take evidence on that issue, but the facts on the ground, so to speak, have changed. That property is no longer, you know, held by that same Chase, you know, mortgage that the you know, trial took testimony on as to whether she had assumed the mortgage first or second. So, you know, you're going to be looking at an entirely different set of facts if the court were to ever say, this is the analysis we need to have. Judge Pan certainly didn't feel like she needed that analysis and went back to the trial court record and decided that Ms. Saunders was not entitled to the specific performance she had requested for multiple reasons. One, the procedural briefing that the court does not want to hear any more about. Second, the issues with the definite terms being lacking. And of course, that is one of the elements that is required before an award of specific performance.
And do you want to take a crack at what definite terms were lacking? Was it just 170 or 153?
And Your Honor, I apologize. I did not participate in the trial proceedings, only coming in at the Court of Appeals level. I believe what Mr. Rousseau has stated is accurate as far as the difference between the two short form contracts.
Don't you think that's a pretty funny ruling or a pretty funny argument? If somebody says, look, we signed two contracts. One was I buy your car for $10,000. One was I buy your car for $11,000. And then we go into, and I say, I want specific performance. I'm happy to pay the $11,000. You say, but it might be 10. So therefore don't order specific performance. I'm willing to pay most, the higher number. It's a funny reason not to order specific performance, well, that maybe I owe even less. It just doesn't seem like you have standing to complain about it.
But again, that is not the current facts on the ground, or, you know, current standing of that property is not as it was back in 2003 when her initial contract was entered into, or both of those short form contracts. So we're not looking at the same terms anymore. You know, again, those four things that Judge Glickman was asking about: the water bill, the attorney's fee payment, the assumption of the first mortgage, and the, you know, payment in full on the second. You know, none of those terms now would be the same if the court, you know, required us to look at whether she was ready, willing, and able to perform those things. That it wouldn't be the same analysis.
If I remember,
none of the terms would be the same, or none of the facts going.
None of the facts with respect to that analysis would be the same.
Right. We don't have a record as to what the current situation is.
And again, I read the mandate as this, you know, the same as Mr. Rousseau, which is that go determine whether specific performance is warranted. There was a however many day jury trial on that issue. And the court, on remand, looked at that trial testimony significantly and made that legal analysis determination as to whether there were definite terms, and determined no, there were not. That is within her sound discretion to make that ruling. And I don't think there has been a claim that there has been a clearly erroneous finding in that regard. Similarly, I don't think.
I guess the way
Is
I
that
look
a
at
factual finding? I mean, is
I
that a
think that-
factual?
I
That
think that
sounds
it,
like a legal determination that there aren't definite terms to a contract.
I think she made factual findings that she was not ready, willing, and able to go to closing. That I believe is a factual finding. And I do think that the finding on the no definite terms, and I don't know that she went any further on that legal analysis track than the no definite terms. But that, again, if she reaches that point in that finding, she has made a determination at this point that Ms. Saunders has not met the legal burden to move forward with a grant of specific performance. And I don't think that has been shown to be clearly erroneous. As Mr. Rousseau cited, I believe in the record at SA 653 and 654, again, this is Judge Pan really delving into the record. She says, I do see some efforts to become ready, willing, and able, but not ever the full ready, willing, and able requirement to be able for me to grant, specific performance. So she went into the trial record at great lengths, and asked about the assumption of the mortgage, asked about the payment of partial attorney's fees, but not all. She went into and revisited the trial testimony on those issues, which is assuming, she assumed that was what this court wanted as a result of its mandate to her. And again, we posit that none of those findings have been shown to be clearly erroneous. Under CF Independent Management Company versus Summers, the Court of Appeals should be bound to those determinations. There were other findings as well by Judge Pan, which was the seller of the property, Stephen Hudgens, was not before the court due to a bankruptcy stay. I don't know if the court has any questions on that finding as well. But there were multiple reasons given for the overall substantive ruling denying Ms. Saunders' request for specific performance. And we don't think that any of them should be overturned on appeal.
Ms. Alexander, I
Certainly.
want to try to wrap my mind a little bit around the right way to think of this legally. I'm thinking that perhaps the way this should have been looked at is as follows. A record was made at the initial trial on which Judge Macaluso at the time should have determined whether Ms. Saunders was entitled, if she wanted it, to the remedy of specific performance. And if that record supported that, Judge Macaluso would have said, okay, you have your choice now. You can take the $40,000 breach damages, monetary damages for the tortious interference, or I will order, enter a judgment granting you specific performance. Now, when we remanded, I think we were asking Judge Pan to make that determination. And the choice would then be based on that record. But I would think that because if Miss Saunders was no longer able to perform, then she would simply choose the damages remedy instead of specific performance. But I would think that if anybody was going to raise changed circumstances, it would be either Mr. Arnold or the bank. I guess Mr. Hudgens was not participating. Does that sound right to you? And if that's true, my question is, did Mr. Arnold or the bank raise the objection that, well, things aren't now what they were then, and there's no point in ordering there's no point in granting a remedy of specific performance now if it's simply impossible to carry out. You see what I'm saying? I may not understand the law here well enough.
No, I do, Your Honor. And I do think that at the December 3rd, 2018 hearing, the issue of whether new items of evidence, should be entertained or whether Judge Pan was going to be limited to the record. There was a brief discussion on that. And, again, it was determined that she was going to be reviewing the record and that was all.
And let me just interrupt you if I may.
Yep.
Are you saying that neither, there are three parties, no party asked Judge Pan to consider new evidence beyond the record of the first trial?
Appellees certainly did not. And I believe Mr. Lasley was trying to get the court to entertain potentially some additional information. And the court said, I believe.
What additional information was Mr. Lasley trying to get the court?
I don't know, Your Honor.
Yeah.
I don't know.
Mr. Lasley can tell us on rebuttal. Okay.
And if Your Honors don't have any more questions, our position is that the court needs to affirm Judge Pan's re-entry of the 2012 original order with respect to judgment. Thank you.
Thank you. Mr. Lasley, you have a few minutes for rebuttal.
Yeah, thank you. I think that the most important point is what Judge Pan ordered is that she was going to follow what Judge Macaluso said. That's her main order in June 7th of, I think, 2019. I'm not certain the date, but she did not do a separate opinion or reasoning of what the mandated issue in terms of what the Ruth Saunders, the appellant, could be arguing for. So this argument from the appellee that about the terms and stuff, none of those things were even discussed. So one of the things that we argue, and one of the things we would ask the court to seriously consider, that you cannot argue about the terms of the contract out of context of why the contract was not fulfilled. So
Mr. Lasley, I get that. One question is whether on the record that was created before Judge Macaluso, the evidence showed that at that time, Ms. Saunders was ready, willing, and able to perform. The other question is at the proceedings on remand before Judge Pan, did you or any party ask Judge Pan to go beyond the record of the trial, of the previous trial, and receive additional evidence?
Well,
Either of current circumstances or anything else?
Unfortunately, before
Just
Judge
answer
Pan,
my question.
I'm sorry.
I'm a slow thinker, so I want to go through this step
Go
by
ahead.
step.
I am too, so don't worry about it.
Well, we're the slow thinker society. It's a good society. So just tell.
I'm sorry. Go ahead.
Did anybody in the proceedings on remand ask Judge Pan to receive additional evidence beyond what was presented in the trial before Judge Macaluso?
My recollection, Your Honor, has been several years, but my recollection is that when I came before Judge Pan, I made an attempt to highlight what the appellee was trying to say. I think what was said and what Judge Pan focused on was the whole thing. She dictated that hearing, and in that hearing, she focused on what the appellee had said. So it was no real effort, opportunity to go into details or ask that. She never really asked any questions about that. And what we had simply argued, Your Honor, is that the focus is on why Ruth Saunders was unable to perform at the time that these conspiracies and tortious interference had occurred. And we argued those two things cannot be separated by arguing the terms of the contract and understanding in a bifurcated case, Judge Macaluso had made a decision that we could have had specific performance, but that we had selected to take the money down. We didn't select that. That was the case. That was how the second trial came about.
Refresh my memory, back when the
Yeah.
case was before Judge Macaluso,
Yes, sir.
after the jury awarded monetary damages, was it contemplated that there would be the further presentation of evidence before Judge Macaluso on the question of specific performance? Or was it understood that Judge Macaluso would then decide on that record whether there would be?
No,
Specific performance.
she had said that she would consider the specific performance request based on, in the context of what the TOPA plaintiffs was also saying. So she had made statements that she had ruled, she was pertinent to ruling, considered ruling based on what the TOPA plaintiffs were saying and based on what the jury had said about Mr. Arnold, that in terms of Ruth Saunders, that's when she decided at the trial for Judge Macaluso that she decided that she would consider specific performance in the context that that's how Ruth Saunders and the TOPA plaintiffs could decide based on her rulings what other kind of damages are ready. And that's the whole thing about damages under what the appellate is saying, that Ruth Saunders is not entitled to any kind of remedy. And what the mandate said, that she could argue for a mandate, would argue that she could have specific performance if there's circumstances to support that. And what we maintain throughout all these trials and motions is that Ruth Saunders can rely on the wisdom of the verdict and the jury, who saw the evidence, who focused on the case, and you can't negate that her right to a remedy, which they and the appellee's counsel said they don't know where Arnold was. There was no opportunity to ask Arnold to do anything, because they said that at the last hearing before this court, he said he didn't know where he was, and they had not, and Ruth Saunders had not got any monies from him. So the bottom line is, I think this court is maybe on the first impression, you can't rely on specific performance in the abstract. This court has to make a decision on what can be done in situations where one of the parties has really destroyed rather the ability of the other party to perform, and then try to come back and argue that the party didn't perform because of the circumstances of the tort or the conspiracy. We maintain that that's the key issue here, is that Judge Pan never addressed that. And the court asked whether or not she could have done specific performance. She tried to do specific performance even before the case even sent to Judge Malaco. The first trial was even decided. But the decision and findings of the first court, and what Judge Macaluso in her order and opinion focuses on those factors, and we would only argue to this court that maybe it's new law, nor principle. The bottom line is, you cannot negate a party can have any remedy whatsoever, and she has a right to try to elect that with the evidence. And I don't think if we rely to the circumstances of the terms of the contract and whether or not Ms. Saunders was able to perform in the abstract. It has to be within the context of what the jury said. The jury said what Judge Macaluso said.
Okay, this is the last thing. I don't mean to interrupt you, but I think we have your argument, and your time has expired.
Oh, well,
I think
that's
there's always more time.
Well, thank you very much. Thank you for your indulgence.
Okay, and we will take the case. The case is now submitted, and I can excuse all counsel. You may log off.
All right, thank you very much. All right, that's it.
We'll call the third case now. This is American Studies Association versus Bronner et al. Counsel?
Good morning, Your Honors. My name is Tom McGavro. I'm here on behalf with Maria LaHood and Mark Kleiman on behalf of the appellants. If I may, Your Honor, we'd like to reserve 3 minutes for rebuttal. I would also yield 3 minutes of my time to Ms. LaHood and 2 minutes to Mr. Kleiman, leaving me, I believe, with 7 minutes. My math is accurate. I know that's a little
I
confusing.
think it may not. Well, we'll find out if it's accurate or not. Go ahead.
Thank you, Your Honors. Again, may it please the court, my name is Tom McGavro. I am here for most of the appellants. I won't take the time to list them all. Your Honors, this case is part of a nationwide campaign to suppress the critics of the Israeli government and the supporters of the BDS movement. This case, Ms. LaHood will speak more specifically as to this, but this case arises entirely out of the 2013 adoption of the academic resolution. That is, and I don't think there could be any question about it, that is an act in furtherance of public advocacy on a matter of public interest. The appellants here, the defendants below, have demonstrated the prima facie showing for the required under the Anti-SLAPP Act. And as this court has said,
I would have thought that you wanted to argue that this doesn't have anything to do with speech, right? That your claims are about, that the claims at issue are actually about corporate control of the ASA, right? And that violations of the bylaws and breach of fiduciary duty, and that the speech that occurs in this case is downstream from that.
No, Your Honor, that's the appellee's position, I believe. And they have said that in the Superior Court. I think they said that in their briefs. They may very well say it today. I don't think it is credible.
Why not? Right?
Well,
I mean, we have a complaint that has claims for breach. There's no defamation claim. There's no, false light claim. There's no claim of intentional infliction of emotional distress about anything that is said. Everything goes to what's happening internally within this organization. And ultimately, people are unhappy about a resolution that is passed by the organization as reconstituted with new leadership. But the claims are not about the speech. The claims are about what the plaintiffs below thought was the co-opting of this organization.
except, Your Honor, that the quote co-opting of the organization unquote is only alleged to have occurred by people with a particular viewpoint.
But let's focus on the statute, right?
Yes, Your Honor.
5501 defines what an act in furtherance of a right of advocacy on issues of public interest means, right?
Right. Yes.
Any written or oral statement,
Yes.
right? The claims don't have anything to do with a written oral statement. The claims have to do with breach of fiduciary duty, breach, right? Like if we're looking at the claims as pled under the counts of the complaint.
Your
right?
Honor, I have to disagree. I think the claims all have to do with the actual speech, with the content of the speech.
Can you point me to the complaint and the claims raised?
Well, Your Honor.
Because I'm looking at the complaint.
Yes,
and
I mean,
maybe you're going to point me to the facts, but I'm looking at the claims.
I think
unless you think claims means something different under the SLAPP Act.
No, Your Honor, I'm looking at the counts of the complaint.
Okay.
And breach count one.
Where you want me to look.
Oh, I'm sorry, Your Honor. I would have to scroll through, but we're looking at the unredacted complaint, and that is going to be forgive me, I am scrolling as we talk.
It's a long complaint.
It is a long complaint. And while I'm getting there, okay, count one is at page 96 of the joint appendix. That's where we'll start. Breach of fiduciary duty. They didn't, the defendants did not tell anybody that they supported BDS when they were running for office, and they used their platform to pass a resolution which, God knows, everybody should have figured out was a bad idea because it's pro-Palestinian. You can't argue with that. Plus, they then used funds to defend a pro-Palestinian resolution. Now, I would point out, Your Honor, that the ASA has passed numerous resolutions on various topics. They
Okay,
don't.
I'm sorry, but let me just, it's breach of fiduciary duty against the individual defendants.
Yes.
And it's material misrepresentations and omissions in connection with elections to office and seeking a member approval.
Right.
These are internal communications, right? So I get that you want to say it's speech, right? It's about speech. But under
Yes.
165501, an act in furtherance of the right of advocacy on issues of public interest means a written or oral statement in connection with an issue under consideration or review by a legislative, executive, or judicial body, none of which applies to ASA,
This one.
right? Or any other official proceeding authorized by law, or in a place open to the public or a public forum in connection with an issue of public interest. Again, not the ASA, not the internal elections of the ASA. Or would
Again,
you
Your Honor,
disagree? Do you think the election process within the ASA is a public forum?
Your Honor, first, I think that the campaign statements, if we're looking solely at count one, the campaign statements certainly are a public forum because they're broadcast to the entire membership. Plus, this is not just, within the National
It's a
Council.
private organization, no?
It with thousands of members. Plus, Your Honor, I would stress
Do you have any
again.
support for that? That's just an interesting thought, that the ASA is a public forum, and I'm wondering what support you have for that. Because that doesn't strike me as what I think of a public forum as, but maybe I'm ignorant of the full scope of that term.
I think, Your Honor, 2 points, if I may. First of all, the resolution, everything stems from the passage of the resolution.
I don't want to go to the resolution right now. I really want to stick to the material misrepresentations and omissions in connection with the elections to the ASA. And you think that those are public statements, and I'm wondering if you have any support. And so, maybe you do, or maybe you just think that's the right answer. Either one, it would be interesting for me to hear, but I'd like an answer to that question.
Certainly, Your Honor. I think the campaign statements, again, they were posted to the membership at large, which meant they were broadcast to a large section of the population.
Okay,
A section of the population.
I'm hearing from you that you would like that to be the right answer, but you don't actually have any support for that position.
I do not have case law support for that position. No, Your Honor, I do not. And I'm afraid.
Mr. Mugavero, if I may
Yes, Your
leap in here, I just want to be sure. My understanding has been that there is one and only one thing that has been treated in this litigation as an act in furtherance of the right of advocacy on issues of public interest within the meaning of the Anti-SLAPP Act. And that thing, that act, is the resolution itself, not any other communications, statement, whatever, expression that may have occurred in the history of this case. And so the issue for us, if that is true, is whether whether any of the claims asserted by the plaintiffs in this case, quote, arise from, quote, the resolution. Is that a correct statement in your view?
Not entirely. If I may nuance it a little bit, Your Honor. And I would say I'm getting into Ms. LaHood's area here.
The only issue as to the first prong of the ASA.
Well, yeah, no. I think there are 2 points to this. Certainly,
I don't mean to interrupt, but can you tell us the areas that the three of you are going to touch on so we know where to direct our questions? Because I don't think we've heard that yet.
No, I'm sorry, Your Honor. I was going to talk about the second prong, whether or not the plaintiffs have met their burden. Ms. LaHood was going to talk about the first. But I can certainly speak to Judge Glickman's question. Your Honor, I think certainly the academic resolution was the genesis of the entire lawsuit. That is the keystone. If that resolution had not been adopted, this lawsuit would not have happened. They would not have brought any of the other claims because they wouldn't care.
So do you think,
Oh, I'm
Sorry.
sorry.
I just wanted to go back to the statute to say, the statute doesn't say if the genesis of the lawsuit is speech, then you can bring an anti-SLAPP motion to dismiss. The statute says that if there's a claim that arises from an act in furtherance of a right of advocacy on issues of public interest, right, then you can file a motion to special motion to dismiss under the Anti-SLAPP Act. And it seems to me that the claims arise from sort of basic corporate governance, nonprofit governance issues, and the speech is downstream from that. And I understand that you disagree, but I'm just in interest of full disclosure, that's how I read the statute. And maybe Ms. LaHood can talk about that. And if I've been talking over my colleagues, so I'll let them ask you other questions, but you don't have to respond to me at the moment.
Thank you. Actually, to get back to Judge Glickman, the second part of Judge Glickman's question, certainly had there not been the academic resolution, this case would not have been filed and they never would have filed any of the claims. However, there is an other element to this, and that is that the plaintiffs have not sued any of the members of the National Council that did not profess pro-BDS sentiments, which means
So what? I mean, they can sue whoever they want to. Why does that
Yes, Your
make
Honor.
more of an anti-SLAPP than not?
But now we're getting to what an anti-SLAPP or what a SLAPP suit is. They have chosen the defendants who disagree with them, and they're dragging them into this case, and they are making them suffer this lawsuit, not because they care about the corporate governance, because let's face it, they didn't raise any objections to the resolution in opposing the North Carolina bathroom ban, the resolution on a minimum wage hike, the resolution on apartheid in South Africa. That's below their radar. It's the pro-BDS resolution that drew their ire and that dragged everybody into this lawsuit.
what I hear you saying, counsel, is that you take a rather broad view of what the phrase arises from in the statute entails, that you think if its factual genesis was a speech act, then a suit arises from that speech act. And I suppose I'm just wondering if you can articulate for me what you think arises from means.
Your Honor, I think arises from is either, and this may be somewhat generalized, but either it is where the factual genesis for the lawsuit, where the factual impetus for the lawsuit is some speech and some act in the furtherance of the right of advocacy on a matter of public interest. It could also be where the thrust of the litigation is to oppose and to contest a specific act in furtherance of advocacy.
So these are pretty malleable tests that, you know, get us a little bit nervous when we announce that. But I have two questions. One,
Okay.
Can you point me to the strongest case that you have for that proposition? It doesn't need to be in DC. You can point me to any case that interprets an arising from in a similar statute in a similar way to what you're proposing. And second, if that's your proposal, do you want to make an argument as to why it's a good one, a good interpretation of the Anti-SLAPP Act?
Yes, and I'll take the second part first, if I may. Anti-SLAPP is intended to protect the right of speech in public forums. It is intended to give the defendants who have made a public profession of some kind protection against SLAPP suits, strategic lawsuits against public participation. In other words, and this court has said that numerous times, the act is a substantive right to go out and speak in the public forum without having to worry about going through years of litigation. You do not want to endanger that right by taking too narrow a view of arising out of, because clever litigants can write lawsuits that are SLAPP suits that nonetheless shave the edges. And you don't want to get in a position where the only SLAPP suit that this court will recognize is a defamation case or a false light case or an intentional infliction of emotional distress case, and leave it to clever plaintiffs to bring more mundane breach of contract, breach of fiduciary duty claims as SLAPP suits and get away with it.
Okay, so I take your argument is that if we don't adopt a robust version of arises from, plaintiffs can smuggle in suits that are targeted at speech under the guise of some other umbrella, breach of contract, intentional infliction of emotional distress. And then you want to answer the first part of my question. Do you have a case that you think is the most helpful to you on that point?
Most compelling on that point, Your Honor, on any number of the cases that we cited from the California jurisdictions, they have, I will say they have a broader view of anti-SLAPP, but I think certainly the one that comes to mind is the Hasimovich versus Encino School Parent Teacher Organization. That's at 203 Cal-App 4th 450.
Given your concession that California statute is broader definitionally than ours, do you have any other authority from a jurisdiction that has a statute more akin to ours?
The California statute, although it is interpreted broader, nonetheless that has similar points, and the Hasimovich case
does it define an act of furtherance in the right of the right of advocacy on issues of public interest in the same way that we do?
If for that particular case, it does not deal with some of the differences between the statutes. California does allow anti-SLAPP when the case arises out of a ongoing litigation, which I don't think the DC statute does not, but that Hasimovich does not involve that particular distinction. The Hasimovich, again, the case was whether or not was statements about a high school coach. And even though the claims were mainly breach of contract and the acts of the school board, it nonetheless fell within anti-SLAPP. I have taken far more time than I need. If I may touch briefly on the point that I was
Yes, you may. I was going to ask you to do that. I have, like everybody else, I suppose, follow-up questions. I'll save them for Mr. Hood.
Thank you.
So get ready, Mr. Hood. But Mr. Mugabarro, I take it you want to speak to the second prong, the defendant's failure, I take it you would say, to present evidence to show that they have a likelihood of success on the merits.
And that is precisely right. That is precisely right. And assuming the first prong is met, which I understand there are questions about, the plaintiffs had the obligation to put forward evidence to show that their case had a likelihood of success on the merits. And this court, again, has said repeatedly, if they fail to do so, the case must be dismissed with prejudice and attorney's fees must be awarded. In this instance, plaintiffs did not put forward any evidence whatsoever. They quote a number of emails in both the unredacted and the redacted complaint. But I would proffer first, their quotes are not evidence. They are allegations of what the emails say, and they should have put the emails into the record. Either
I remember correctly that they included at one point, and I'm blanking on the point, the deposition of what's his name, Mr. Stevens?
John Stevens, they did quote from the deposition. They did put a part of that deposition into the record, but that was on the question of whether or not Mr. Barton was allowed to vote, which is clearly a time barred issue. However, and this is for the 2 points, excuse me, the two types of claims that remained after Judge Rigsby ruled on the 12B6 motion fall into 2 camps. One, the financial aspect, whether or not the direct national counsel and the individual defendants breached their fiduciary duty by spending money to defend the resolution. The second one is the editor of the encyclopedia contract. None of the, there are no.
I would add a third, although maybe you would say that this is all included in the 12B6 claims that were granted by the judge. I would say that there's that some of their claims relate to actions that were taken to prevent the opponents of the resolution from exercising their rights to advocate against its adoption, or to prevent members of the, relatedly to prevent members of the association from being adequately informed about the resolution. Now, are you saying that those only the claims that were dismissed on 12B5, 12B6 grounds were in that category? I think so, but you may be right.
Those, yes, the claims that were dismissed under 12B6 fall into that category. What happened in 2013 during the process by which the resolution was adopted. And those claims, again, I think Judge Rigsby properly dismissed those as time barred, which means they had no likelihood of success under anti-SLAPP.
So what we have then are 2 types of claims then that are specifically anti-SLAPP. One is you wasted and misappropriated money of the association, and the other is you punished opponents by, or at least one opponent, I guess, by removing him. One opponent, by removing him from the editorship of the encyclopedia.
Right, and that's
or not continuing, however one.
Or not renewing, precisely. And there are no quoted emails relating to the finances. And in fact, I would proffer, we go into this in our brief in detail, the allegations in the complaint regarding the financial aspects of their claims are self-contradictory, and in some cases not supported by public documents such as the Form 990s. So the plaintiffs have...
Let's say we agree with you that the defendants simply failed to present evidence as they're supposed to show a likelihood of success on the merits. Is the proper, let's assume that's the only issue before us for the sake of simplicity here. If we found that, what would we do? Remand and say we're reversing the judge's denial because the plaintiffs did not carry their burden. Would that leave them open on remand to fill the gap and submit evidence supporting their claims and showing the likelihood of success? Because the judge did dismiss did deny, he did not grant the motion. Or are you saying we would have to order the judge to grant the anti-SLAPP motion?
We would argue that we would have to be remanded for dismissal of the case on the grounds the plaintiffs did not meet their burden. Once Judge Rigsby found that the first prong was met, he should have required them to present evidence. They failed to do so. At that point, as this court has stated, the case must be dismissed with prejudice and attorney's fees must be awarded. It is a presumptive right to attorney's fees.
So Judge Rigsby, under that scenario, your understanding is Judge Rigsby could not say, oh, all right, we all made a mistake. We thought the complaint and the various representations were sufficient. I'm going to give the plaintiffs a chance to show with evidence that they could, on a claim-by-claim basis and so forth, defendant by defendant, claim by claim, that they have a likelihood of success on the merits. You think Judge Rigsby does not have discretion to do that on remand?
I think in this instance, I mean, there have been two opinions by this court since Judge Rigsby held the hearing and made a decision, but Competitive Enterprises v. Mann was issued before the hearing and before his ruling, and I think Competitive Enterprises states that what the standard is and what the requirements are. So everybody was on notice.
Dan, for a second, because you said you're talking about presentation of evidence. And
Yes.
I'm wondering exactly what you envision by that, because Mann talks about the production or proffer of evidence.
I think
Doesn't talk about presentation of evidence, which would suggest to me, full-blown hearing with exhibits versus a proffer, which could be more informal by counsel.
I think in this particular case, given the again, looking at the first part, the financial aspect of it, I think they would have to at least proffer and file with the court some documents to show that their view of the financial transactions is in fact at least enough to get to a jury.
Did you make that argument? The trial court?
Complete would not be enough.
I'm sorry, Judge Deal.
I've
I'm sorry.
spoken for Judge Deal. Go ahead, Judge Deal.
But mine is really a yes or no question. Did you make this argument to the trial court?
We did make the argument in the reply brief that they had failed to present evidence, yes.
When you say reply brief, you mean in the reply in support of your anti-SLAPP motion?
Yes, Your Honor. We did, and of course, we didn't raise it in the initial motion because they hadn't responded yet. So it was only in the reply brief that we could say, well, they haven't done it. On the other part of it, and I've gone way over, I apologize.
It's okay.
On the other part of the editor's contract, they have two problems. First, the contract by its explicit language states that they don't have to renew. So you can't form a cause of action for not doing what the contract allows you not to do. But more importantly, again, the part of their claim is
That can't be quite right, because you could have tortious interference with a prospective business advantage.
But
I mean,
all of the defendants purportedly, according to the complaint, all the defendants acted in their capacity as members of the National Council. We won't get into the fact that by the time these things happen, half the defendants weren't members. But so the corporation can't conspire with itself. That's a basic. But still, their argument, it's a lesser part of the complaint of that particular account, but part of their theory is that the editorship was a vital, valuable, and vibrant element of ASA's operations. Again, that's not supported in the record. There's no evidence of that. There isn't even a quoted email in the complaint about that. It is simply, he didn't think his contract should have been terminated because he thought he was doing a good job.
Well, one reaction, and I guess I'm interested in your view on this. One reaction I have is that if there should have been a sifting of evidence on a claim-by-claim basis in the trial court, and if the judge didn't do it, this court should not ordinarily, at least, undertake that task in the first instance on appeal, but should rather be sending it back to the trial court to do that. Do you have a reaction to that view?
Your Honor, I think it would be one thing if the plaintiffs had put into evidence, had filed exhibits.
They put in sufficient evidence. But,
and Judge Rigsby simply said, you know what, I don't need to deal with it. I don't need to look at the exhibits. They didn't. They didn't even put the exhibits into the court record for Judge Rigsby to look at. So in this case, it's not like they actually gave him something that he ignored. It's that they didn't meet, they affirmatively.
Yeah, I want to draw a distinction. I take your point that this court can say to the plaintiffs, you didn't even try.
Right.
To do what you had to do on the second prong. So we cannot, we must reverse on that basis. it's another thing to say, well, we've heard Mr. Mugavaro point out the various reasons why various claims can't survive, and we'll go through this claim by claim ourselves and agree or disagree. That's a different sort of inquiry for us to undertake. In the first instance. You see what I'm saying?
I see the distinction, Your Honor, although given the burden of the plaintiffs under the anti-SLAPP, I think having failed to meet that burden, I think the court could look, well, let me put it this way.
Why would we? If we felt
Well,
they failed to present any evidence, why would we go further?
Well, Your Honor, I think that the fact of the matter is claims can fail for law reasons, or legal reasons, or for factual reasons. In this case, they failed for both. And I think, yes, having failed to put any evidence into the record, I think the plaintiffs are pretty much done. But I think this court, as a matter of law, could look to the complaint and also say, for example, tortious interference won't succeed because you can't conspire with yourself. That's one example. I'm going to shut up now and yield to Ms. LaHood before I get in any more trouble with her. Thank you, Your Honors.
You're welcome. Ms. LaHood?
Thank you, Your Honors. Maria LaHood for Defendant Salida. I would like to address some of your initial questions about the first prong of the Anti-SLAPP Act. I don't think that it's plaintiff's claims that you look to, because the Anti-SLAPP Act says it's the alleged act from which those claims arise. And I think the broadest, the best case to look to for that, for the phrase arising from is actually one we cited in our brief. It's Algernon Blair. It was from this court from 1989, saying it's well settled that statutory language employing the phrase arising from accepts a broad, general, and comprehensive coverage. Direct causation is not required. It's enough that the claim would not have arisen but for the presence of the asserted predicate.
But that's not an anti-SLAPP case.
No, there is not an anti-SLAPP case interpreting arising from in DC.
Right, and I guess I just had, when you start off by saying this doesn't have anything to do with the claim, I have trouble with that, because the statutory language of 165502 says the movant must make, that means that the person seeking to get a special motion or filing the special motion to dismiss, right, has to make a prima facie showing that the claim at issue arises from an act in furtherance of the right of advocacy on issues of public interest. And it seems to me we know what claims are, right? Claims are the things that you put in your complaint. And you say, well, I have this many claims, right? And then the act that arises from, and then we have act in furtherance of the right of advocacy on issues of public interest, and that is defined by statute, right? So,
well, the first answer is that the statute actually defines claims, and in that definition, it includes complaint. It includes causes of action. It includes other kinds of claims. So I think you can have a case like this from which the entire complaint arises from one act. But I can talk about the various acts. If you want to look behind the boycott resolution, I can also talk about those acts. But first, let me just talk about this court's decision, recent decision in Saudi American Public Relations Affairs Committee, in which the court mentioned the three claims at issue once, and then it never mentioned them again. It went straight to the nucleus of facts, and it didn't even analyze those statements individually. It lumped them together and talked about how they were made in the context of the larger policy.
If I remember right, this issue about whether or not the claims arose from an act in furtherance of advocacy was not teed up for the court. So it doesn't surprise me that we didn't dig into this. Is that right, that this issue was not raised in any way, or the court wasn't concerned with it?
The plaintiffs did not challenge that the academic boycott was a matter of public interest, but there was briefing on whether the act applied.
I'm sorry, I meant in Saudi America.
Oh, sorry.
That's okay.
that they didn't allege that it was.
There was no argument about whether or not the claims arose from an act of public advocacy, whether or not the Anti-SLAPP Act applied under that term. So I mean,
Well,
I guess I'm just saying, I don't
certainly
read
about whether it was a public interest. It was whether it was connected to the public interest. And
Sure.
if you look at the definition in the act, you know, an act in furtherance of the right of advocacy means one of four things or three things. Each one of those talks about in connection with an issue of public interest. So both of these. So if you look broadly at what's in,
you have to have speech in a certain forum, right? And so I mean, in the Saudi Arabia case, which I fondly call SAPRAC, it was a blog post, right? And it was a defamatory blog post. And then there were other claims in relation to the blog post, but it was speech to the world in an unquestionably public forum, right? On the internet to the world, right? Whereas here we are talking about actions taken within an organization that are alleged to have violated bylaws and rules of corporate governance. And, you know, you can say this is all about the resolution, but the fact of the matter is that if, you know, assume that these things happened, these bylaws were breached, or assume that they didn't happen, right? Then these people don't have those claims, right? Maybe the speech is the downstream event, but their objection that they are coming to court to seek redress for is the fact that the organization has been co-opted in this way. And they wouldn't be able to come to court and make those objections if, in fact, you know, everyone had disclosed on their platform for election that they really wanted to support this election, this resolution, right? And if they hadn't closed the voter rolls on the day, or the membership rolls on the day of the election, right? It's all about the process. It's not about the speech that comes after.
I think, so let me address what are the underlying factual allegations underlying the claims. So I represent Dr. Salaita.
Just before you do that, can you set the table for me a little? Is your response that this is a factual inquiry? That what arises from, a claim that arises from an act of speech is an intensely factual inquiry? Is that the premise that you're starting from?
No, I think you look to the if you don't accept that the boycott resolution, which is the reason this case is brought, satisfies the act that you need, then you look to the actual.
I think everyone agrees. I think everyone agrees. All parties agree that the resolution satisfies the act requirement.
Oh.
That's not the issue. The issue is whether the claims here arise from that.
So
can I ask you a question or two?
Can I? But I would like to answer the question about arising from, about whether they arise from. But yes.
Oh, okay. I wanted to do it before we get into the facts here, but go ahead.
Oh, go ahead. No, go ahead.
I don't want to. Go ahead. I can wait.
Okay, so if you look at the plaintiff's only specific factual allegation against Dr. Salaita is his advocacy for the 2013 boycott resolution, as evidenced by a 2014 op-ed that he wrote. So that is obviously, and that op-ed said he worked closely with, or worked with US ACB closely during the process of to pass the ASA resolution. That is advocacy he did, was communicating views to members of the public on an issue of public interest. So count 12, which is for his advocacy, arises from his statements to the public. And, they don't even, he wasn't on the National Council at this point. He was what they allege, part of US ACB, who was advocating for the boycott and advocated the ASA to pass the boycott. So that is square within the anti-SLAPP law, even if you go behind the boycott resolution. The other two allegations that were talked about that are against Dr. Salaita is that he was on the National Council when the decision was made to expend money on the lawsuit, on defending the litigation that was brought by plaintiffs. Funding litigation is considered expressive conduct involving petitioning in the government, or it could be statements made in connection with an issue under consideration by a judicial body. That's what it is. There's a case, we cite several cases that talk about that. So the funding to defend litigation, which is what they're actually claiming was done, falls under the anti-SLAPP statute, that specific language. One of the things they mentioned, and this was
I wonder about that. Just because something is expressive and covered perhaps by the First Amendment does not necessarily mean it falls within the definition.
well, I don't think it's just because that. I don't think it's only because it accords with the First Amendment. I think it's because it actually falls within the language of petitioning the government or statements made in connection with an issue under consideration. You're paying your lawyers to make those communications with the judicial body. That has to be covered.
See, it seems to me you may be right when you point to things like the claims you just mentioned, that there are some claims that do survive the requirement of prong one. But it seems to me that that doesn't necessarily address whether all the claims here.
All the claims against Dr. Salida
Against
fall under
Dr.
these categories.
Well,
So let me just go with
we
the other
understood
claim.
your role. We understood your role in the advocacy here this morning
and-
to be
But
more broadly covered prong one.
but these are the main claims against all defendants. So
Well, let me ask you about that. Here's a hypothetical. Suppose a claimant, a member of the association came along and said, you know, I love this resolution. I think this resolution is the best resolution that has ever been issued by this body. However, I'm really offended by the process by which this was conducted because the rights of me and other members of the body were in various ways interfered with. And I'm really offended by what they did to Professor Bronner and so on and so forth. So I'm filing these claims. I think there were breaches of fiduciary duty here. It's a matter of principle for me. The fact that I happen to agree with the resolution doesn't mean I agree with the process by which they did it. Now, suppose you had that person before you and the judge credited, or a jury could credit, that you could say, that testimony. Would you still be saying that the anti-SLAPP motion applies?
I think
He would say it doesn't arise out of the resolution. I don't care about the resolution. I care about what these people were doing. My claims arise before the resolution was even issued.
I think it's important to look to the purpose of the statute. As the DC Council said, and as Mann affirmed, the purpose is to assure that defendants can fend off lawsuits filed by one side of a political or public policy debate aimed to punish or prevent the expression of opposing points of view. So you look behind it and you say, this case is brought because the people disagree with the boycott resolution, and all the claims flow from that. If I can just talk about the one last claim.
Can I flip it then? What if I hate the resolution? And I'm so mad at your client that I sue your client for something totally different, right? I decide I'm going to sue him for breach of contract because he sold me a car. What was that car, Judge Steele, that you were trying to sell in the earlier case?
It was a Buick Skylark.
It was a Buick Skylark. He sold me a Buick Skylark and it was a lemon. And we were friends and I was willing to kind of put up with it and just tinker with it on weekends. But then he went off and, passed this resolution and I'm mad and I'm going to take him to court and sue him for breach of contract for selling me a dud car. Anti-SLAPP motion? Because it's arising out of his.
I think you might have a malicious prosecution claim, but if there's no actual act.
It really is a dud car.
So I'm sorry.
I have a valid breach of contract claim or an arguable one. It's not malicious. I mean, it's malicious because it's motivated, I guess, because of this speech. The genesis, to borrow Mr. Mugavero's language, is the resolution. But there's a real arguable breach of contract claim based on whether or not he disclosed the faults with the car.
So the defendant would have a right, if they wanted, to bring an anti-SLAPP motion, and there would have to be evidence submitted. So they could say, I mean, they would have to point to the act. They could use evidence maybe to say, here's this backstory. Here's why I know I'm being targeted, but there has to be something that's a statement or expressive conduct in the anti-SLAPP statute. And then there would be evidence put forth, proffered or produced, to decide whether those claims were likely to proceed. Again, this is just the first prong. There's also a clump.
Your answer is motive is enough. It can be a claim that is entirely separate from any speech act, so long as the motive behind the lawsuit is a speech act. Is that right?
I'm not saying that, Your Honor.
Okay.
I'm saying, because I think there are acts here. There, every single, again, and if I can get to the final act, every single.
I appreciate that.
It has to satisfy the statute.
My hypothetical. So why is Judge Deal's question about motive or inquiry? He was confirming. You're saying motive is enough if you can connect it to speech downstream, which was my hypothetical, and now you're saying no. So we're just. I don't
think motive is enough in both in Mann and in Saprick and in Close It and in Friedman. Everyone looked to context, right? So you can't necessarily just look at the statements to know. You have to look at the bigger policy debate and what's actually going on.
But those cases don't help you so much, because in those cases, right, the claims were related, I mean, directly premised on the speech, right? I mean,
it seems to me that it's being suggested that only defamation claims can be challenged by the anti-SLAPP statute, and that's just not the case.
No, my hypothetical was, I have a claim that is not premised on the speech, but is motivated by the speech. And I'm asking whether the anti-SLAPP, whether you can file a special motion to dismiss to get that case kicked out of court in a case where it shouldn't be kicked out of court on 12b6 grounds or summary judgment grounds. This is a case that should go to a jury. But the motive is there, and I'm trying to figure out whether you think the Anti-SLAPP Act applies.
I think you have to apply the statute as it says, and you need to be able to point to statements or expressive conduct that fall within the act. So I don't know about the car salesman, or whether that. I think context matters. I don't think intent is enough if the case does not actually, if the claims don't arise from an act in furtherance of advocacy on a matter of public interest. So if I could just go to the last claim, which is that Dr. Slida, again, was on the National Council when Dr. Bronner's contract wasn't renewed. And we've also already gone through the fact that he had no entitlement to renewal under the contract, which I can say more about. But basically, Bronner's allegations are that defendants didn't renew his contract solely because of their difference of opinion on the boycott resolution. They say that at 4 different points in the complaint, which I'm happy to say. So the factual allegations that Bronner purports support his claims are that defendants spread false statements, that he conspired to undermine the ASA because he opposed the resolution. His own factual allegations supporting his claim of non-renewal of the contract, which were for breach of fiduciary duty and tortious interference, are essentially a defamation claim. They're that the defendants, not Dr. Slida, but the defendants indiscriminately spread false information about him to the public. Those are clearly claims under the Anti-SLAPP Act. And again, I think here you look to the in connection with an issue of public interest. Saprick, even though there were statements that focused on the plaintiff as an individual, the court found they were made in the context of a firestorm between 2 competing Middle East special interest groups. This was a firestorm around the boycott resolution. It's not just that Bronner only sued people who are involved in US ACB and no one else. It's that he, looked to the context. He also pulled his entire department that he chaired from the ASA. He brought this litigation against the ASA about the boycott resolution. So if you look to you don't even have to look to the broader context here, because if you look at what he alleges that they spread false information about him in connection with an issue of public interest, the boycott resolution. You mentioned the bylaws. There are two
Are
different
you not
bylaws.
bothered by the sweep of your interpretation of the Anti-SLAPP Act statute?
I am
Totally
not, Your
good.
Honor, given the purpose of the Anti-SLAPP Act, which is to fend off this litigation, plaintiffs can provide evidence to show that their claims have merit. If they do that, the Anti-SLAPP Act doesn't apply and they proceed. But if they are targeting speech with meritless claims that they can't provide evidence to support, then the DC Council has found in the balance of the interests that the case should be dismissed under the Anti-SLAPP Act.
When you say targeting speech, you see, that's really getting, I think, to the issue that I find myself grappling with, which again is the scope of arises from. A claim for breach of fiduciary duty in the conduct of an election, for example, or in the use of entrusted funds, does not, in its content or proof, have anything to do with an attack on speech. It's a claim that focuses on non-speech activities that are not protected or not intended to be protected by the Anti-SLAPP Act. What's bothersome is when that sort of a claim is marshaled, even if it's meritorious. But your point is, if it's meritorious, then it survives. That puts a lot of faith in the procedures of the Anti-SLAPP Act. What's troublesome is when somebody looks at that claim and says, well, we can tell that the real reason they're bringing that claim, their real motive, is because of their apathy or antipathy toward our particular act in furtherance of public advocacy. And that strikes me as a very hard standard to apply. How does the judge, now here you could say, well, we could look at their complaint. They made the mistake of throwing in a lot of stuff in the complaint about the resolution. Well, maybe, but that is this notion, it really does sort of focus on motive, because the substance of the resolution, the merits of the resolution, don't really have anything to do with proving the various claims, relief that would be obtained in this lawsuit. Most of them. I think you may have a point about some of them. So I don't want to get bogged down in the claim by claim detail. You see the problem, and I wonder if you'd comment on it.
Well, there are two things, Your Honor. One, I think, if you say that some certain kinds of claims are exempt, like fiduciary duty breach, you can, a plaintiff could fashion their claim in a way to avoid the Anti-SLAPP Act application. It is not about the claims. It's about the factual, assuming that it's about the factual allegations undergirding the claims. And in this case, I've gone through all the factual allegations that undergird the claims against Dr. Salida, and they all—
Against Dr. Salida, I understand.
I'm
looking at this now from the perspective of a judge who has to decide.
Right.
Again,
I don't think it's motive, and I'm sorry if I suggested it was earlier. I think you can look at the actual acts that are alleged, and the statements or the expression or the expressive conduct, and see if
Can I jump in and say, you said you can't carve out certain claims, and I don't hear anyone on the panel suggesting that you would carve out, for example, breach of fiduciary duty, right? I could see a case where you have, an officer of the organization make write an op-ed that someone then says, look, that op-ed, the content of that statement somehow breached your fiduciary duty. You disclosed confidences, or you somehow breached your fiduciary duty to the organization when you made that public statement, right? So I don't think anyone's talking about carving out certain types of claims, but what we are saying is what are the claims? It seems like you have to start with the act in furtherance of the right of advocacy on issues of public interest, and you build out from that. The claim is based on that. And here it seems like the claim is based on these breaches of fiduciary duty and bylaws and all of that stuff.
A breach of fiduciary duty, Your Honor, is the claim. The factual allegations are exactly as your hypothetical. They're exactly the same. They are that defendants, all of them, may spread false information about plaintiff Bronner to the public. If you look on at the allegations, there's no one has mentioned any other allegation underlying the fiduciary duty breach or the tortious interference breach besides the spread of false information. So it's, and it is that example. It is precisely that example. You can't just say the name of the claim and say it doesn't apply. You have to look at what are the facts supporting that claim. And if you look on page, pardon?
I'm sorry, I apologize. I shouldn't have interrupted you.
That's good.
Well, let me, before you sit down, I'll ask you just one hypothetical further to crystallize the scope of your claim. And I respect that this is a difficult issue where there's arguments on both sides. So suppose money is entrusted to the officers of the association, and money is entrusted saying this money is to be used for the encyclopedia and the parties we have at which all the members get together and for a few other purposes. And the officers say, we have a really good use for this money that it really was not intended for, but we have a really good use for it. It's to publish this resolution and get us involved in that larger dispute that's very much in the public domain and public interest. And so they, in effect, use that money for a purpose for which it was not entrusted, and the resolution is issued. And the people who had an interest in that money, the members of the organization, who say, well, you're not using that money for the purpose it was meant to be used for, and we as members are injured that way. Leave aside whether it's a derivative claim or a direct claim. That's not really the issue here. I take it your position is that a suit for misappropriation of those funds, for reaching into that bank account and taking it out when you had no authority to do it, would be at the very least subject to a motion to dismiss under the Anti-SLAPP Act, and the first prong would be satisfied. Do I understand your position correctly or not? Now, your answer could be, well, yes, but there's a safeguard because the plaintiffs can show that the second prong is not met. They have a good chance of success or a likelihood of success on the merits. I just want to know how you react to that hypothetical.
I think it depends, Your Honor, for the first prong, what those funds were used for. But again, I'm no longer arguing that you can't look behind that, correct? If it's used for litigation, if it's used for publishing the statement, if it's used for, those kinds of things would fall under the act. If it's for having a party or whatever that is not going to be considered expressive conduct.
No, my point is it's used for the litigation and publishing the statement. It's used for those First Amendment.
Well,
it's used for things that constitute an act.
Yes, if it's used for things that constitute an act, then you go to the second prong and you say, but they violated these bylaws or they misused the funds in whatever way. Which again, when the Anti-SLAPP Act applies, plaintiffs then get to show that their claims are meritorious or at least not unlikely not to succeed, and they can proceed.
Now, but I guess what bothers me about that conclusion is that it really does go, I think, well, no, maybe you would say it doesn't. So in other words, even if the plaintiffs credibly say, look, we love the resolution. It's just that we don't like you spending our money, for that purpose. And that's why we're suing. You would say it doesn't matter that it's not motivated by antipathy to the resolution.
Right.
It's just the objective facts. That's your position.
Yeah.
So, okay. Okay. So, Mr. Hood, I take it
So
you're at
you
the end
know,
of
I
your
can go to
5
the
minutes,
claims
or
if you
2
want.
minutes, or 3 minutes?
Sorry, I know I'm over time. I could go to additional reasons that the claims are not likely to succeed, but it seems like that's not where the focus is. So I can also end.
Well, I think we did hear from Mr. Mugavero on that, and we're about to hear from Mr. Kleiman, I think, right?
I mean, there are some additional reasons for Dr. Salida. If I
All
just
right, take a
do it
minute or
quickly,
two.
I guess.
I know you have a
Um,
specific client and you're concerned to have his interest.
You know, he's for the tortious interference claim. Defendant Salida was on the National Council at the time, which plaintiffs concede at paragraph 332 of their complaint that they wouldn't have a tortious interference claim against him. So the other one is just.
Well, maybe I should ask you this question then that is similar to what I asked Mr. Mugavero. Putting aside the first prong issue, if we were just dealing with the second prong issue, don't we have to remand for the trial judge to deal with the claims and the evidence supporting them that can be adduced to support them, issue by issue, claim by claim, defendant by defendant?
I think
Which wasn't done, or
the
at least not explicitly done.
well, again, I think under the Anti-SLAPP Act, you know, the claims can fail on the law and they can fail on the facts. I think here they also fail on. I mean, it is true that plaintiffs did not submit evidence to support them. I believe they all fail on the law as well. So I think that analysis could be done by this court. If the court's so inclined to remand, to consider, to give plaintiffs another chance to consider evidence and to proffer evidence, then yes, that's something that would need to be done by the trial court.
Dude, I'm sorry, just to ask one last question on that point about claims failing under the law, you know, on essentially on 12b6 grounds. Do you think that likelihood of success under anti-SLAPP is synonymous with 12b grounds for dismissal?
No, but I think if a claim
Or
fails
I
to
asked
state a
my
claim-
question. I asked my question badly, not synonymous with, but likelihood of success would incorporate both sort of your ability to substantiate with facts and any legal defenses against those claims.
Yes, I think that if a claim fails to state a claim under 12b6, then it is not and cannot be likely to succeed on the merits.
And why, I mean, first of all, in Mann, we said the anti-SLAPP statute is not supposed to be redundant of 12b6. So is that consistent with our statement in Mann?
Yes, because the Anti-SLAPP Act provides additional protections, right? You can bring it early. You can get resolution to the claims quickly by the court. The court is mandated to hear it quickly. You can get attorney's fees with the statute. You can also, there's interlocutory appeal. So there are various ways that the Anti-SLAPP Act offers protections that are not covered by 12b6.
Right, but we didn't make the statement about redundancy in those in the context of talking about attorney's fees or earlier relief, right? We were talking about the need to present evidence to respond to the prima facie case, which just suggests to me that we were envisioning the anti-SLAPP statute as providing sort of a different quality of protection, separate and apart from the procedural protections that are available under 12b6.
Right, that's, you know, the evidence part is what makes it more like Rule 56, but it's obviously not a substitute or, you know, for Rule 56 either. I think it's a blend so that you can use 12, you know, you can say that that the allegations fail in the law, but if plaintiffs provide evidence, then you need to contend on the level of the evidence. So you need to do what's essentially a Rule 56 review. So
right,
I think
but you see where I'm going. I mean, this is an open question, I think, still in our jurisdiction, how to interpret the statute and whether we say, hey, these sort of procedural defenses that you could raise under a 12b6 motion that have nothing to do with the quality of the claim can be raised under a special motion to dismiss and can generate attorney's fees. We've not said that yet, right? But you
No,
think we
but
should,
well, in Mann, you said that it includes, you know, claims and defenses, right? When you look to, I guess, and that was in the context of whether a case.
but those were substantive defenses to defamation, right? I mean, it's whether or not someone's a public figure or whether, right? Am I wrong about that?
But I think it said, you know, as opposed to procedural. I think here we're talking about the substance of the claims. We're just not necessarily talking, we're just saying that you can decide them on the law or you can decide them on the facts. Clearly, at this stage, we went on the facts because plaintiffs didn't supply any evidence whatsoever. So we could stop there, but we're saying they also fail in the law. That means that they're not likely to succeed on the merits. There could be procedural, you know, procedural arguments that wouldn't satisfy that. So in that way, 12b-6 is different from anti-SLAPP as well. But if it's a substantive reason to dismiss the claim, then it's not likely to succeed on the merits.
Thank you.
Thank you, Your Honor.
Thank you. Mr. Kleiman, it's your turn.
Thank you, Your Honor. Mark Kleiman here on behalf of Professor Kate Halani and Professor Puar. Under either anti-SLAPP standards or traditional 12b-6 standards, the claims against all of the defendants should be thrown out, all of the individual defendants, because of the immunities afforded under the Federal Volunteer Protection Act. There is no question that the act applies in DC. The DC Corporations Code actually specifies that the code will not limit, you know, any rights or immunities directors or volunteers may have under a federal statute. In the
And
initial,
Judge Contreras rejected this argument, right? In the DDC?
Judge Contreras rejected that argument. That's correct, Your Honor. However, Judge Contreras also ruled that none of the plaintiff's derivative claims that actions by the defendants somehow harmed either the ASA or the individual members of the ASA survived, that these plaintiffs could not advance under Article 3 claims that were not their own. Yet Judge Rigsby below in the Superior Court used precisely the argument of derivative claims, which the plaintiffs are collaterally estopped from litigating, to hold that the anti-SLAPP statute doesn't apply. Excuse me.
It sounds like you're making a good for the goose, good for the gander type of argument. You know, if you messed up one way, then you should mess up our way too. I guess my question is, what is your view or response to Mr. Marcus's argument that we shouldn't revisit the immunity question, seeing as how it was decided by the DDC? And I think there was an opportunity to appeal it, given that you guys did take an appeal to the DC Circuit in that case, and it never raised that issue.
The immunity question, as ruled on by Judge Contreras, as we understand it, was essentially mooted because of Judge Contreras's findings that there were no derivative claims possible. So the underlying factual premise is different in the Superior Court than it was in the District Court. Had Judge Contreras gone on to rule on the merits of the derivative claims and to say that those claims were not protected under the VPA, then we would have, I agree, then we would have a different situation. But that's not what we're confronted with. So it's our position that once the Superior Court motion to dismiss was ruled on, we should have gotten, once the claims alleging derivative harm to either the ASA or its members were precluded, there's no way under the law that Judge Rigsby could then return to those claims which cannot be advanced and say that these are somehow beyond the purview of the Volunteer Protection Act. The other piece of this statute, which I think is very, very central to this, is that the VPA requires a showing that there was an intent to harm individuals. And that, you know, without a showing that there was an intent to harm individuals, there's no way to get out from under the immunities afforded by the statute, which is, according to its own terms, intended to be interpreted broadly to afford protection and to encourage people to participate in voluntary and nonprofit organizations.
Mr. Kleiman, one thing I wonder is whether, given that Judge Rigsby did not address this argument, whether we should be addressing it in the first instance, or whether it should be addressed on remand.
If it were to be addressed on remand, I'm not certain, Your Honor, that it would be fruitful to have it addressed on remand, for the simple reason that the plaintiffs are collaterally estopped from asserting derivative claims. So,
well, right, I understand.
I'm not sure. Yeah,
You may have a 12B6 motion here rather than simply a summary judgment motion on this ground.
What this was part of our 12B6 motion, Your Honor.
But the 12B6 motion itself is not, I mean, if you think of it in isolation, let's put it that way, it's not appealable at this time.
That's right.
This being an interlocutory appeal limited to the denial of the anti-SLAPP motion to dismiss.
Oh, I would go back to what my colleague, Ms. LaHood, pointed out, which is that if a cause of action is barred by 12B6, it's challenging to understand how the plaintiffs could possibly demonstrate a likelihood of success, which is the anti-SLAPP standard, given the fact that they're barred from proceeding with the claim in the first place.
How far do you think that proposition can be pushed? Suppose there were a 12B6 motion in which that is purely procedural in nature. The motion says service of process was inadequate, the claim should be dismissed, or personal jurisdiction. Is it your view that regardless of the ground for granting the 12B6 motion, the court must still consider whether the anti-SLAPP motion to dismiss based on those claims should be granted as well because of the availability of attorney's fees, or perhaps you have some other reason why you would say that?
Well, first of all, my answer to that question, Your Honor, is yes.
So regardless of the ground on which the 12, suppose, I mean, sometimes, well, all right, go ahead. Okay.
Yeah, I mean, the literal words of the statute are likelihood of success.
Yes, but we've suggested that that's some sort of term of art, right? And I guess I'm wondering why on earth would that serve the purpose of the statute? If I have a winning defamation claim, but I, fail to serve my complaint properly, but substantively it's a winning claim, why would any SLAPP apply to that?
Well, this goes back to the question of what the motivation for bringing the winning defamation claim was, and whether
I don't think it does. I think
arose from-
I think you're skipping to a different issue. I think we're just talking about what likelihood of success means. And my thinking was that likelihood of success was really related to the essence of the claim and whether it was a claim that was trying to silence speech, legitimate speech. But if I have a winning defamation claim that just loses for some other reason, a procedural reason, I don't understand why the putative defendant should get attorney's fees for that. I wasn't trying to silence legitimate speech. I was trying to defend myself against defamatory speech in my hypothetical.
Okay, well, perhaps I'm misunderstanding something, Your Honor, but I have a hard time dissecting the idea that this is a defamation claim from why the claim is being brought in the first place. Because if the claim was not being brought in an effort to retaliate or silence, speech about a matter of public interest, we wouldn't be there. The idea of an anti-SLAPP statute is that plaintiffs don't get to drag people into court on claims of questionable merit because of their speech act. If a claim is obsolete because of the statute of limitations or other grounds, and somebody is dragged into court on a defamation action, are they in any way less inconvenienced, expensed, chilled in terms of future speech because the problem was procedural rather than factual? I don't think so. The duty of the plaintiff is to bring a claim that A, has some likely basis of support, and B, is procedurally sound.
I have a winning defamation claim, but I'm 1 day late under the statute of limitations. And it was a mistake, that I miscalculated or my lawyer miscalculated, and we thought we could file on the day that we filed, and, it was a screw up. But I have a winning defamation claim. You get attorney's fees for that? Because my claim gets kicked on a statute of limitations?
Well, there are provisions.
I mean, it's undoubtedly late, but it's undoubtedly a winning defamation claim.
Undoubtedly late with reasons for tardiness due to mistake, inadvertence, or excusable neglect make this an arguable claim. So I would agree that at that point, under that limited hypothetical, I think Your Honor is correct. But that's quite a ways from what we have here.
But it's my hypothetical, and I'm trying to figure out why this anti-SLAPP statute would want to apply to that. I hear you saying, well, maybe even if you could file a special motion to dismiss or bring your statute of limitations defense under the guise of a special motion to dismiss and seek attorney's fees, and a judge could say, well, extraordinary circumstances, I'm not going to award attorney's fees. But I'm trying to figure out why the authors of the statute, why the DC Council would have wanted to bring those sorts of defenses under the anti-SLAPP statute, which really seemed to me very focused on free flow of legitimate speech with an element of kind of David versus Goliath. We're trying to protect the little guy from being crushed by big corporate defendants, from keeping, the little guy, the activists, from speaking out on things. The idea that, these various procedural defenses bring this under an anti-SLAPP special motion to dismiss just doesn't seem to square with that.
Well, I'd suggest, Your Honor, that we need to have at that point a factual inquiry. I would submit.
Counsel, can I just ask, maybe see if you agree with this?
Mm-hmm.
nothing stops a trial court from saying that special circumstances make a fee award unjust in that circumstance, right?
That's right.
So the anti-SLAPP statute could apply even to these sort of procedural bars. You know, if it's a meritorious claim otherwise, but it's a day late, trial court could say, well, it's dismissed. Anti-SLAPP statute applies, but I'm not going to award any attorney's fees because when I look at it, this thing was a dead winner. You just got it in a day late.
Absolutely, Your Honor. I mean, the other point is that this is, Judge Easterly's hypothetical is not what our case is about by quite a long shot. We have a case where it's not a procedural objection to the plaintiff's claim. It's the fact that there was a judicial determination after ferocious advocacy on both sides that derivative claims couldn't be pursued as a matter of law. That's substantive. It's not a procedural matter. So it's an interesting inquiry and one that I can see why this court would be concerned with, but it's not a grounds to deny relief to the defendants in this case.
Okay. Are you, you've used up your 2 minutes. How did that happen?
I think I have, Your Honor. I did have a couple of other brief remarks that are specific to my clients, if the court has a moment.
We'll give you a moment. I realize you're representing specific individuals that want to be here.
Thank you, Your Honor. This as to the specifics of Professor Brunner and the editorship, because he is the one person who has an allegation that he was directly injured. There are two things that need to be noted about my clients. The first is that Professor Puar was never on the national committee, the National Council of the ASA. Her term on the nominating committee ended 3 years, more than 3 years actually, before this matter ever came up for review. The idea that she had anything to do with any of this is really quite a stretch. And there's certainly no evidence to support it. And the other point being that Professor Kehaulani's term ended before Dr. Brunner's contract expired. So it's not clear what either of them could or should have allegedly done about this under any circumstances. And of course, since there's been no evidentiary showing, we never had an opportunity to discuss that at the lower court.
Okay. We will give, you'll have to think among yourselves how this would work, but we will give you some time for rebuttal. Let us hear now from, excuse me. Well, actually, the name I have here is not quite what I expected to see. Are we hearing from Mr. Marcus?
Yes, sir.
Okay.
Can you hear me?
I can hear you. Let us hear you from you, Mr. Marcus. Thank you.
I think there are a couple.
The reason I said what I said is my list of participants lists Jennifer Gross, who I take it is not arguing. Is that right? Did you hear me?
No, sir, I did not.
Oh, I said my list of participants identifies Jennifer Gross as the attorney who's arguing. I take it she is not arguing.
She is not, and the court graciously granted my pro hoc application last week.
Yes,
and that was,
I remember
so
that.
I could argue. I think there are a couple of preliminary points, many of which are I think embedded in some of the questions that the panel has been asking, particularly Judge Easterly. that allow us to make this path a little bit straighter and less confusing. The first point is that this is, as Judge Easterly's question suggested, this is a case about corporate governance. This is a nonprofit organization, and there was an effort essentially to launch a hostile takeover. And it really is no different. The claims here are no different than the claims that would be prosecuted in a normal corporate context, where there was an effort to take control of an organization that has members, it has votes, it has a board of directors, it has solicitations for votes, it has the use of corporate assets, and all of the actions that are at issue here relate to those violations. They do not relate to speech. And the way you can tell that is that the DC legislature has given us, the DC Council has given us help here. We're not just trying to decide what the right answer is on a blank slate. There's a statute, and the statute says in two different sections, it gives us a lot of useful information. The first thing it says is that a party may file a special motion to dismiss any claim arising from an act in furtherance of the right of advocacy. So what is a claim? And what is an act in furtherance of a right of advocacy? Well, happily, the statute defines those things. And it defines them as follows. It says a claim includes any civil lawsuit, claim, complaint, cause of action, cross-claim, counterclaim, or other civil judicial pleading or filing requesting relief. It's exactly what we all know as lawyers. It's a count. It's not a reason for a count. It's a legal claim.
What about Ms. LaHood's point that it says a lawsuit, which seems to be a broader umbrella term that might refer to a collection of claims and the foundational facts?
I agree that it could include a collection of claims, but when you're talking about dismissing a lawsuit, we all know what that means. That means you're filing a motion to dismiss. And what it means is that, I mean, just think about the word in English. What is a claim? Well, it's a demand that you owe me something. I have a claim on you. It doesn't mean you committed an act. It means you committed an act that gives rise to a claim. So if you put your hand in the cookie jar and you took out money from an account that you weren't supposed to use for anything other than specified purposes, that's a claim. But it is a claim because it's a claim that gives rise to a claim for relief. And I think that's the right way to understand it. We don't have to torture the English language to understand it. And it makes sense of the statute that way. It also avoids all of the other problems that the court, I think, was confronting about, well, how much do we have to get into motive? How much do we have to get into why these people are here rather than those people? And here I want to take a little...
Counsel, maybe we don't in this case, because your complaint makes it quite clear that the impetus for it is their adoption of the 2013 resolution, without which there would be no claim or lawsuit.
Well, it doesn't make, first of all, I don't think it does make that clear. And I'll adduce two important facts, one of which is inconsistent with what all my friends have been saying, and the other of which is something that they've just ignored. And the two facts are, A, there are plenty of people on the board that we didn't sue who have lots of the same opinions. And the second is that there was one defendant, Avery Gordon, whom we dropped as a defendant. If you Google Avery Gordon, you will find that she is a prominent advocate for the boycott, divestment, and sanctions movement against Israel. We dropped her as a defendant because when we got their emails, we found out that she hadn't participated in the acts at issue that give rise to the claims. So we dropped her. We didn't sue everybody that we disagree with. That's just, it's a canard. It's just not so. There are plenty of people we disagree with that we didn't sue.
Mr. Marcus, I think the problem is that one term the anti-SLAPP act statute does not define is arising from or arise from. And the question before us, I think, comes down to, at least with regard to the first problem, the question before us comes down to how broadly or narrowly we define that term.
So I think the right way...
Judge Rigsby, for example, can be said to have given it a fairly broad interpretation when he said that if it had not been for the, he said boycott, but he meant the resolution. If it had not been for the resolution, we wouldn't be here. And That's not a frivolous argument by any stretch of the imagination, because we have case law giving a broad interpretation to words like arising from. And we do have a concern by the council to protect the kinds of advocacy that the resolution represents. So I'm interested in your take on how broadly or narrowly, how we should define arise from.
I think it should be facts that give rise to a claim. And I don't think that that risks the problems, because just as it's clear that here we didn't sue people who engage in speech just because they engage in the speech that we don't like. We only sued people who put their hand in the cookie jar or who disseminated false information in the same way that you would do it if there were a proxy contest in a corporate context.
Well, I think one thing they're saying, though, is that you only sued the subset of people who put their hand in the cookie jar whose speech you didn't like.
No.
There's a whole lot of other people who put their hand in the cookie jar that you didn't sue.
If they're saying that, I'm not aware of it, and I'm not aware of anybody who put their hand in the cookie jar that we didn't sue. We've alleged there are improper expenditures made, and everybody who we thought was responsible for those improper expenditures, we sued. And if they weren't responsible for it, we didn't sue them. And I think that's one of the reasons that we dropped Professor Gordon. So it's just not the case that there are people who, I mean, I don't think there's anybody who, engaged in improper financial expenditures, but wasn't a supporter of BDS. And so we said, okay, well, let's not sue them because they're our friends.
Can I just read in response to Judge Lickman's question, the case that Ms. LaHood cites? I'm just going to read from Algernon for a second, where it says, it is well settled, but the statutory language employing the phrase arising from is broad. Granted, it's a different statute, but the next part is, it has been held to suffice where a claim is said to arise from some predicate, that there be a substantial connection or nexus between them. That's enough. So, if there's a substantial connection between the speech, the 2013 resolution, and the claims that are being asserted, we might say that the claims arose under the reasoning in Algernon. Now, I suspect you have some distinctions or why we shouldn't read the Anti-SLAPP Act so broadly. But what's your response to that case's rather broad interpretation of the statutory phrase?
My recollection is that in that case as well, the facts that were said to have a connection to the claim were the facts that gave the plaintiff the right to go to court. And I think that if you were to expand it beyond that and you start asking, well, why are these people really here? I mean, lawyers appear in front of courts every day for one reason, because they get paid. And we don't ever say, well, you're not saying that because you believe it. You're saying it because you're getting paid to believe it. We look at the merits of their argument. If the merits of their argument are valid, we adopt them.
I mean, I think they've disavowed a let's look behind at the motive. I think they might even agree that we could stick to the face of the complaint. And if that were true, that might solve your conundrum that, if we stick to the face of the complaint, it sure looks like this is being motivated by the 2013 resolution. You don't think so?
No, for precisely the reason that I think animated some of the questions, which is I guess one way of saying it is this: there are other academic societies that have adopted these resolutions that didn't get sued, and they didn't get sued because they didn't breach their fiduciary duty on the way to doing it. And so the question is not, who am I paying attention to? The question is, what did I sue you for doing? And if there's a breach of fiduciary duty, we're entitled to enforce our clients' rights for breach of fiduciary duty without asking, excuse me, I'm sorry. Well, without asking, well, why, Mr. Lawyer, are your passions engaged in this case? That's not an appropriate question. The question is, what are the merits of the claim? What is the claim based on? and
It's
the other
not like the complaint in this case doesn't have a lot to say about the resolution.
Well, it doesn't have a lot to say about the resolution, and I think that's a point in our favor. We're not debating the merits of the resolution. We're not asking the court, I mean, in previous rounds of briefing in this case, we've gotten hundreds of pages on the merits of the Arab-Israeli dispute. We're not here about that. We're not asking the court to decide anything about that. And I think it's also important to note that the only false information that we focused on has nothing to do with the merits of that dispute. In other words, we didn't say, oh, you promoted this resolution by saying false things about Israel, or false things about the Arabs, or false things about Palestine. That's not what happened here. The issue was just, did you actively conceal your program when you were trying to get control of the organization? That's a bread and butter corporate governance question. You've got people running for, I mean, there are people who are trying to take over or get seats on the board of a corporation all the time. And they issue proxy statements or they issue communications that says, this is what I want to do if I get on the board. And if those statements are false, they're actionable. And if
Suppose there is evidence presented to the court that, irrespective of the merits, and the claims may have merits, but the motivation is in bad faith, designed to interfere with or penalize people for their public advocacy.
Well,
Does
the
that
money
make a
goes in,
difference in your view?
I think the rabbit goes into the hat.
The act?
I'm sorry. I think the rabbit goes into the hat when Your Honor says in bad faith. I think, is it in bad faith because the reason why these plaintiffs brought this case is because they didn't like the resolution? I don't think it is, as long as the claims are real claims, they're substantive claims. You don't only have to sue people you like. There's no rule.
That gets you out of any anti-SLAPP Act dismissal.
No.
If you show any merit to it, you don't have to worry about it.
Well, first of all, there's merit and then there's merit. But I think the first prong is, what are you suing them for doing? And that focuses on the claims. It doesn't focus on why do you really want to be here? There's no part of the statute that asks that question.
What do you say to their argument that it would gut the anti-SLAPP Act statute to say that if you focus on the claims themselves, then you can crafty lawyers can very easily make legal arguments that do not state the First Amendment basis of why they're really bringing their claim, that it's going to leave it an empty act, that's going to be vexatious litigation, can run rampant without any check on it.
Okay, so I think there are two answers to that question. The first is that the DC Council, unlike other jurisdictions, including, very importantly, California, specifically decided that it wanted to limit this statute to speech, right? And we presented in our brief the earlier version of this statute that went beyond that. That included expressive, other kinds of things that were related to speech. And we showed in the legislative history that the legislature decided, no, we want to limit this to speech. That was the legislature's conclusion. So it seems to me if the legislature concluded that, then that's where the inquiry stops. And then the other way of understanding it is in the question about the sale of the Buick Skylark. If I decide to enforce my rights against somebody that I'm mad at for some other reason, I don't see why that's relevant. If I have rights, I have rights. If I don't, I don't. And we don't ask why you're here. I mean, it's a general matter. You have no obligation to only sue your friends. And I think the suggestion that we're suing these people because we don't like them is not asking the right question. The question is, what did you sue them for? And does the case have merit? And the statute provides that in the what did you sue them for part of the inquiry, the only thing you can get in trouble for suing them for under SLAPP is speech, because it defines it in a particularly narrow way. It says an act in furtherance of the right of advocacy on issues of public interest means, and then it lists things off. Any written or oral statement made in connection with blah, 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 in a place open to the public, which was one of Judge Easterly's questions. Any other expression or expressive conduct. Putting your hand in the cookie jar is not expression or expressive conduct. It's just not. And if the DC legislature, the DC council wanted to say, well, you can reach conduct that's not expression or expressive conduct if your claim is animated by hostility to expression or expressive conduct, they could have written the statute in a different way.
Animated by does not sound so different from arises from to me.
No. But the issue is not, the issue is, no, it is different because animated by is animated by the litigants or their lawyers. Arising under allows us to look at the allegations and the claims and what is the relationship between those two things. They're objective. It's
So
not
suppose the
asking,
allegation is you did something that you shouldn't have done. You had no authority as the officer of this organization to make this resolution, to issue this resolution. We're suing you because you improperly issued that resolution. Now, is that, in your view, sufficient to satisfy the first prong? And let's assume that you have a good argument that the officers did not have that authority.
Okay. I think the difference is that there it's just speech. All they did was talk. They just issued words. It's like a defamation claim. Whereas the argument is, I mean, for example, suppose, I'll give another example, which I think is consistent with.
You embarrassed us members.
Right.
Something along these lines.
Right,
you know.
right. I published an editorial.
Resolution in our name, which we don't believe in.
I think.
Now, my reaction is that sounds like it falls within the Anti-SLAPP Act, at least at first blush.
I agree. I think it would, because it's expressive conduct. You wrote an editorial. You wrote an editorial that took a position that's at odds with the position of the organization. And you can't do that. I think, yes, I think because it's expression. It's not putting your hand in the cookie jar. It's not tortiously interfering with a contract.
You used some of the organization's resources to issue that resolution.
Now we're in a different.
And then when you were sued, you used some of the, I don't know, the organization's insurance company.
Right. Well, you said this is a business expense. I wrote
one of the examples I think given by Ms. LaHood was using funds to litigate.
Right. I do want to point out that our claims about financial impropriety are not limited by any means to money used to pay the lawyers in this case. Okay, I just want to make that clear. But yes, it seems to me that if the argument, I mean, think about it, let's abstract from this and let's just think about it in a less heated context. You have a corporation and the president of the corporation, it's a publicly held corporation. The president of the corporation writes an editorial and he gets sued and he tells the company's lawyers to defend him. That's a garden variety breach of fiduciary duty claim. And it's not speech. He's just using corporate assets for his own personal purposes. And then there's going to be a question, well, did he write the editorial in his capacity as an officer? And was it to advance the office company? Well, we all know how to do that. We know where we are in that context. No, there's no great amount of creative lawyering required to work our way through that problem. But the legislature here has given us a distinction. It said speech is covered, not speech, not covered. So yes, I think that if they simply issued a resolution and said, we think X about Israel and the Arabs in Palestine. Yes, I think if we had sued them for that and said, you breached your fiduciary duty by speaking on that topic, I agree, that would be covered by the SLAPP Act. But that's not what we sued them. There's no part of it.
I started to count how many times the resolution is referenced in the complaint and I stopped after 100.
Okay.
So we just ignore that?
No, you don't have to ignore it. The question is, what's it doing there? In other words, is it there because we said this resolution really stinks and therefore you owe us money? Or is it there because we were talking about the resolution and the question was, you put up the resolution for a vote, you counted the votes wrong, you froze the voting rolls, and then, by the way, you ultimately had a vote about the resolution. That's the third time I've mentioned it. And you didn't get 2/3 and you said the resolution passed. That's the fourth time. So yes, if I mentioned the resolution in the context of saying the rules required a 2/3 vote, you didn't get 2/3 and you said you won. Yes, I'm talking about the resolution. What isn't in the complaint, Your Honor, and I think this should allay Your Honor's concerns, what isn't in the complaint is the substance of the resolution. In other words, we're never complaining about the resolution said X, but it should have said Y.
But isn't the fact, if the claim itself is frivolous, if it's meritless, isn't that pretty strong evidence that the basis for it is the one that jumps off the page? So let's say that the argument was they needed 100% of the vote to pass this resolution, and that was plainly inconsistent with the bylaws, and that was the only claim you had made. I would think they'd be able to say, look, this claim really arises out of the passage of the 2013 resolution, and you should dismiss under the Anti-SLAPP Act because this other thing is just a total pretext that they're using to vexatiously litigate that issue.
My answer to that is, no, they should not be able to do it under Anti-SLAPP Act. They should be able to do it under Rule 11. They can't.
Yes, but the whole point of the Anti-SLAPP Act is to prevent that type of vexatious suit against First Amendment practices, and it seems to be gutted if you're allowed to do it through an end run.
No, because in the example that Your Honor just gave, the thing that was done wrong was not a First Amendment practice. I came into court and I said, you counted the votes wrong. That's a corporate practice. I was clearly full of baloney. They didn't count the votes wrong. Okay, I should be sanctioned for doing that. But it's not a speech act any more than it's an act of, I don't know, sex
So I
discrimination.
appreciate that it is not a speech act. My question is more, does it arise from a speech act? And where it appears that the claim is a pretext in order to get at the speech, we might say that it arises from it.
Well, I think that you'd have to torture the statute. Look, I understand.
I don't think that's a tortured use of the word arises from. We said substantially linked in Algernon was enough.
But I think that in a context here where the question is what the statute is asking, the SLAPP statute is asking, what are you being sued for? And it's clear that what the legislature principally had in mind, and the vast majority of these claims arise under, is a defamation claim or something like that, a false light claim, where you're talking about words.
But I'm suggesting that formulaic approach to the anti-SLAPP statute is going to be a very ineffectual SLAPP statute.
No, and I'm suggesting that that's not correct. And what's bothering Your Honor is the possibility that there could be an abuse which would escape sanction. And what I'm responding with is there is no abuse that will escape sanction. There are two different abuses. One of them is an abuse of an attack on speech, and another is an abuse of the judicial process, which we have just plenty of fine tools to deal with. And the fact that, I mean, I'll give you another example. Here's another example. Suppose I sue people because they're Black or because they're Jews, and I only do that. I just sue people because of their religion. And I go into court and I do that. Have I violated the discrimination laws? Maybe, but I violated Rule 11. If I file a meritless case because I don't like the race of the other party, I can be sanctioned under Rule 11. We don't have to invent new things in order to make sure that that kind of abuse goes unpunished or doesn't go unpunished. There's no need to do that. And there's no need to make this statute mean anything other than what it was intended to mean, which is to protect speech. And we're not prosecuting speech here. As I've made clear, we dropped people as defendants who engage in this speech. And there are plenty of other people who engage in this speech that we didn't sue.
Mr. Marcus, you're not asking us, though, to limit any limit the application of special motions to dismiss under the anti-SLAPP statute to certain causes of action, like defamation claims, right? I mean,
no, I think the example that I forget which member of the panel asked, but if I brought a breach of fiduciary duty claim, which is not a defamation claim, but I brought it because I said you spoke, and that constituted a breach of fiduciary duty. I agree, and I agreed before. That would be a violation. That would be reachable under the SLAPP Act because the basis for the claim, the bad thing that I said you did that gave rise to the claim for relief was speech. And whenever that's true, I agree that the SLAPP Act can reach it. But that's not what these people have been sued for. We didn't say you spoke and therefore you owe us money. Your speech constituted the act which gives rise to the claim. And I think the earlier case that the court has been asking.
The claim is, let's focus again on the rises from. Suppose the claim is you spoke, we opposed it. Because we opposed it, you punished us.
Well, then I think all you're really saying is I'm punishing you because of the speech that you made in response, which I agree. If the claim for relief is you spoke, I mean, put it the other way. My clients, which they didn't, and some of them actually don't have a position on the Arab-Israeli conflict. They just don't like academic boycotts. But suppose one of them made a public statement. And somebody else in the ASA made a response and said, he's wrong. Israel's bad, or academic boycotts are good, or some other thing. And we sued them for that statement. Yes, I agree. That would be reachable, regardless of what we called it, whether we called it a breach of fiduciary duty or I don't know what. But if we sued it, and if we sued them and said, the thing which you did wrong, which gave rise to the claim, was words coming out of your mouth, that's reachable under SLAPP, regardless of what you call it. But if it's taking money out of a bank account, it's not. If it's counting votes wrong, it's not. if it's freezing voter rolls where we have email traffic where they actually sit there and say, no, let's freeze the voting roll on this day, because that's the day when we can maximize the number of votes in our favor and minimize the number of votes against us. That's not about speech. That's plain old abuse of corporate governance rules. It would be no different if it happened outside of this context.
Now, Mr. Marcus, let's switch gears for a moment and consider the question of the second prong of the anti-SLAPP statute. The appellants argue that the trial court erred by failing to consider the likelihood of success on a claim-by-claim, defendant-by-defendant basis, and that the plaintiffs failed in their duty to present evidence to support and show that their claims had a likelihood of success. Want to speak to that?
I certainly do. So this panel is astonishingly well prepared as it is, and it's a joy to talk to such a panel, has the great good fortune of not having lived with this case for the last 5 years. And so you do not know that the defendants—
I hope that's true for the next 5 years as well.
Yeah, okay. The defendants in this case have, I won't say abused, because it's not this court's problem to decide if it's abuse or not, but suffice it to say that virtually every document produced in this case was marked confidential, and they have attempted in every forum and at every step to prevent us from using those materials. Most recent and relevant of these incidents is that they fought like the Dickens to prevent us from even filing the redacted complaint in court, even under seal. They didn't want Judge Rigsby to see it. And they fought like heck to prevent us from being able to show these materials to the court. So the idea that they now stand here and say, oh, you guys should have put in the emails and you should have put in the documents, which they threatened us with sanctions for filing the complaint, just filing a pleading in court under seal. And they threatened us with sanctions for that. So if we had the temerity to actually take all these documents, which we obviously have, they haven't denied the accuracy of a single one of these quotations. We got their emails in discovery. We have the deposition transcripts. We have the financial records. We have it all. And it's all marked confidential. If we had had the temerity to say, oh, we want to file this stuff in court so the court can see it, the screaming would have been heard in California. I mean,
well, wait a minute. This is a little hard to imagine. Are you saying that if you had made the evidentiary showing that you claim you could make to establish that there's a likelihood of success on the merits on these claims, and if you had made that showing by filing the documents under seal, that you would have been in, that something prevented you from doing that?
I'm saying that the lengths to which we had to go to file a document which quoted these materials was astounding. And there was never a request to actually see the documents, all of which they have. There was never a claim that the stuff that we quoted was inaccurate.
Can I just ask for clarification? So I asked them if they had raised this argument below. They said they did in their reply. And do you take issue with that? That they said in their reply?
No,
the evidence.
I thought I don't have time to go check.
That's okay. I'm happy to look at it myself. Okay. Do you have a recollection?
I do not. I do not have a recollection, but I do have a recollection of this: that when we were in court arguing the motion to dismiss, the defendants wanted to close the courtroom to prevent us from even using the unredacted complaint. They wouldn't let, and as I said, we filed a motion for leave to file the unredacted complaint under seal. The only people who would have seen it were Judge Rigsby and the court personnel, and they opposed that. And they threatened us with sanctions.
The issue is not simply showing particular evidence, but making the case, the claim by claim.
Okay, so that's the second, right?
how you would succeed. Or
I understand. So that's the second issue. The one is, why didn't you put in the hard evidence? And I think I've addressed that at least as best I can. The second question is, did we need to go claim by claim? So I think the first answer is the defendants didn't go claim by claim.
I noticed that.
All they did was they said, you guys hate us, and that's why you brought this case. And I think we've answered that. We answered the argument that they made. And I think that's what we were required to do. So I don't think we had to go claim by claim. I think that to the extent that, for example, in Mann, where the court did go claim by claim, it went asserted defamatory statement by asserted defamatory statement, which is how you would have to, that's how you would ever have, that's the only way that I can think of to go through a defamation claim and figure out, what are you dealing with here? What do we have? But part of the problem with going claim by claim, and this also relates to the problem of what does it mean to succeed on the merits, is that if you're talking about a claim which is not about speech, it's not a claim that the defendant spoke and therefore owes me money, but it is instead a claim that the defendants took money out of the bank account, or they froze voter rolls, or they tortiously interfered with a contract, or they decided to close down a journal rather than leave somebody running it who took a position they didn't want. And by the way, that's important for two reasons. One reason it's important, and there was some suggestion that, oh, it's just a journal, it's not really an important part of the organization. There are 5 officers of the American Studies Association. One of them is the editor of that journal. And that means that the person who's in that position is in a position of very substantial power, and they have substantial rights, including the right to bring derivative claims. And the defendants decided that they wanted Professor Bronner out of that position for reasons that we explain in the complaint, have nothing to do with the merits of his capacity as an editor, and have nothing to do with their desire to replace him with somebody else, because they didn't replace him with anybody else. They have nobody else.
One related question to the arises from inquiry that we pressed you on a lot is, when I hear your answers, what it sounds to me like is you think you can tell by looking at the complaint, by looking at whether or not a speech act is really being targeted by the claim itself. What's a little troubling for me with that interpretation is the statute speaks in terms of making a prima facie case of the claim arising out of a speech act. Now, if it's true that you can tell by looking at it, if you can tell by the nature of the claim itself, you would think a prima facie case there's no difference between a prima facie case and a perfectly legally adequate case. There would never be a chance to revisit that later because you could tell it all just by looking at the complaint. Whereas if it's a factual inquiry about what's really, the impetus, the substantial link between the speech and the claim, you might think a prima facie case could be undermined by later evidence. But the way you pitch it doesn't seem like there's a difference between prima facie case and an ultimate legal conclusion. Do you follow? I mean, that was convoluted. So I forgive you if you don't follow.
I'm not, I think I might understand the question, but if Your Honor wouldn't mind.
I think just to boil it down, by virtue of saying that the first question is whether or not there's a prima facie case of whether or not the claim arises from a speech act, seems at odds with your view that you can tell definitively from the nature of the claim itself whether or not it arises from a speech.
Oh, because
prima facie case sounds like something that might be undermined by later evidence or factual development, but your very claim-focused approach doesn't seem like a prima facie case could ever later be undermined by it. If that makes sense.
I hear the point, and I respect it. I think my answer would be this. It seems to me what's going on with this statute, out of a desire to protect speech, is that the court is saying, excuse me, the DC Council is saying, you have to make this showing. It may not ultimately be the world's most definitive showing, but if there's a substantial chance that the claim actually arises out of speech. I mean, take our example of the breach of fiduciary duty because you wrote an editorial. Okay? And suppose that the an officer of a company writes an editorial. You know, officers of companies are writing a lot of editorials these days and saying a lot of things about issues of public importance. And suppose somebody comes along and says, Mr. President of Coca-Cola, you shouldn't be talking about that. You should be making fuzzy drinks and not talking about anything else. And it's a breach of fiduciary duty for you to be doing that. Now, is that a question of speech? Well, yeah, maybe. He's gonna argue that it's part of his, he's well within the business judgment rule by deciding that he wants to talk about that, and that it's important for his company to talk about that, and that there are employee relations reasons and all kinds of other reasons for talking about it. So I think what the legislature is saying here is, if it looks like there's a really good chance that that's what's going on, then we have to move to prong 2. And I don't think there's anything wrong with that, and I don't think it undermines the argument that I'm making. And I also think there will be problems the other way, right? I think that we also have a right to go to court. We have a right to petition. We have a right to present a claim in court. That's a First Amendment right too. And I think if the argument is, well, you really don't have that right because we know you're only doing it because you hate those guys, that's going to give rise to problems in the other direction, which would also have a constitutional dimension to them, as was suggested, I think, in one of the amicus briefs. So I think that what the court is doing here is it's really taking a selection of standards from Rule 11, from Rule 56, from Rule 12, and it's saying cases that are about speech, that is to say, cases where what's being litigated is the speech, are of special concern to us. And so we're going to create these rules, which, by the way, are rules where a claim could survive 12b6 and still fail SLAP, or it could succeed under SLAP and fail under 12b6, as the cases that we cite say, because this is a unique inquiry. It's a special animal. And it's a special animal that exists because the legislature wants to protect speech, but it also understands that there are limitations on how you can do that. And so it's created this process, and I don't think that undermines the argument that I've been making about what is the claim really about. What is the claim really about doesn't mean what really is animating these people for bringing that claim.
One final question before you sit down, if I may, on another area.
Please.
There's been some discussion about whether, it's hard to encapsulate this in one sentence, but the interrelationship between grounds to dismiss under Rule 12b6 and likelihood of success on the merits.
Right.
Do you want to speak briefly to your position on that?
Sure.
Issue?
I want to speak. I'll try to make it brief. We've cited a line of cases, most prominently the Hilton case, but also the Park case in the DC courts, which make clear that the 12b6 inquiry and the SLAP inquiry are separate inquiries. And when you think about, I think, this court's decision in Mann, where the court really engaged in an act of very careful creation in talking about what is the likelihood of success. What does that mean? And it fashioned a standard that was unique for SLAP. And it did that trying to balance all of the considerations that the SLAP statute mandates courts consider. And it created a standard which is unique. That's what the court said, and it is unique. It's not just, could you get to a jury? It's not just, does it state a claim? It's a unique set of facts focused on speech, the speech which is at the center of the case, the speech which is said to give rise to the claim, the speech which is wrongful and whose wrongfulness means the defendant owes the plaintiff money. And that was the question. And so that's why there are all these cases that say, no, you can have a situation where a case survives 12b6, it states a claim, but it's still going to fail under SLAP. And you can have a case where it fails under 12b6, but survives SLAP. I do think that the inquiry is complicated. I'm sorry?
I'm perplexed about that notion that you can have a claim that survives under SLAP, but Oh, I've lost you, haven't I? Hello?
There you are.
Did I freeze for a minute?
You
That's because the
disappeared.
battery on my iPad is down
Oh, dear.
to 10%. I mean, imagine a case in which, well, for example, take this case in which the defendants say, look, you can't win your defamation claim against us or whatever,
Well,
because we have immunity, statutory immunity, or because of collateral estoppel defenses, or because the statute of limitations is passed, your claim is completely untimely, and you have no basis to get around that time bar. Just as a matter of logic, it seems hard to say that anything but that the plaintiffs can't show a likelihood of success on the merits under those circumstances.
I think that the inquiry that the court is being asked to make under SLAPP is different, and that's why the timing of these motions is different. A motion to dismiss is due before a SLAPP motion. Motion to dismiss is due 21 days after complaint is filed. The SLAPP motion is due 45 days after complaint is filed. And I think that in the same way that you could have an abuse of process claim, which is separate from a 12b6 claim, where the question is, has the party done something abusive? I mean, the statute of limitations example, I think is a good example. I blow the statute by a day. Okay, I'm out of court, but that's not the same as having committed an abusive process, because the inquiry is different. And I think the inquiry under SLAPP is, and the court said this in Mann, is this a case that wasn't brought to be won? And you could have a case that wasn't brought to be won, even if it failed under 12b6, because the plaintiff did his best. I mean, a very good example is present in this case. We brought claims in 2016 in federal court. They sat there for 3 years, and finally Judge Contreras decided to throw them out. And then we walked across the street and filed them in state court, and the defendant said, oh, look at that, ha ha ha, their time, the statute's blown. And you should have known when you filed in 2016 that you were in the wrong place, even though Judge Contreras wrote 2 opinions in which he refused to throw us out on amount and controversy requirement. So, okay, finally he changes his mind, and we're in court, and we're in court here, and we lose on the statute. Now, do I think, would I concede that even though we lose, assuming he's right, Judge Rigsby, which I don't think he was, but for present purposes, that's where we are. We've lost on statute of limitations grounds. Do I think that means that we violated the SLAPP Act? That means that we only brought these claims because we were trying to silence people? It didn't mean that when we filed them in federal court across the street 3 years ago. So we refiled them now literally 5 weeks after we were thrown out of federal court. We were in state court. We just had to reformulate the complaint and file. Can it be that the same claim in that circumstance, which, assuming Judge Rigsby is right, the statute's blown? So we're not able to establish a claim on the merits. We failed. Can it be that that suddenly becomes a claim that is an effort to suppress speech, a claim that we brought knowing that we had no intention of litigating it to judgment? We just did this to afflict the defendants? How can that possibly be right? It can't be right. There are all kinds of reasons why a claim could fail under 12b6, that being, I think, a good example, where it's perfectly obvious that it wasn't a violation of the SLAPP Act when we filed it the first time. So how can it be a violation of the SLAPP Act when we file it the second time? Now, the defendants will say, well, wait a second, the SLAPP Act doesn't apply in federal court, and they're right. But they had other ways to challenge our motivations, and believe me, they did everything they could to challenge our motivations in federal court as in state court. So yes, I think there are examples where a case can fail under 12b6 and still not be a violation of the SLAPP Act. There are a couple other points that
I'm going to get up while you're talking and see if I can plug this in so that I don't get it.
So you don't disappear again. I don't know if the court wants to hear me on the the merits of these claims, we do believe that the merits of the claim, the merits arguments. Just want to wait.
Go ahead.
Okay.
Thank you.
We do believe that the merits arguments are not properly before this court. This is an appeal of the SLAPP Act decision, and it can't be that every time a SLAPP Act motion is denied, along with a 12b6 motion, that the defendants get to bring the whole case, the defendants get to bring the whole case up to the Court of Appeals. That can't be right. Because it would defeat the entire purpose of creating a special appeal, which this court did in Mann, to address the issues unique to the SLAPP Act statute and its procedure. What the defendants are saying is, what that means is every 12b6 motion that gets denied is immediately appealable if there's a SLAPP Act, if there's a SLAPP motion alongside it. And that just can't be right. That's not what the court said in Mann. That's not what the appeal that was created by Mann was created to do. Having said that, the defendants have suggested that Professor Salado or other people were only sued for speaking. It's just not so. If you read the complaint, it's absolutely clear. These people were sued for engaging in substantive acts of hands in the cookie jar, approving hands in the cookie jar. Professor Salado was on the board when the bylaws were changed without notice to the membership to permit larger withdrawals of money, and that money was used to fund the defendant's hobby. That's a hand in the cookie jar claim, Your Honor. That's not he said something we don't like claim. The same for Professors Puar and the other individual defendants whose lawyers have spoken here. The Volunteer Protection Act does not apply when willful action is alleged. The statute does not require that the willful action target an individual. If you read the statute, it's clear there's a comma, and it's talking about willful action or action that targets an individual. It's not willful action that targets an individual. Two courts have rejected that argument now. And as I say, it's not properly before the court, but if it is, it should be rejected, just as the other two courts have rejected. I don't have anything else. If the panel has more questions, I'm happy to answer them. Otherwise, I'll be quiet.
Okay, counsel, thank you.
Thank you.
Let us hear now how the appellant's counsel want to respond, since there's three of you.
Thank you, Your Honor. I will take just 2 points to clarify the record, and then I will cede to Ms. LaHood. These 2 points. First of all, on the question of sealing the complaint and filing the unredacted complaint, we did not, and we never did argue that Judge Rigsby could not see it, and we did not argue that the motion should be, the hearing should be closed. I think the transcript is clear on that. Our argument on filing the unredacted complaint was simply that it was way too long, and the redacted complaint was too long. Rule 8 requires a short motion, a notice of pleading, not a 300-page tome. I would also, and on that point, well, no, I've made that point. On the question of amending the bylaws to stop, make sure that Dr. Bronner was not an officer, that had nothing to do with derivative claims. We've made that argument in the reply brief. The fact of the matter is the derivative claims were dismissed because plaintiffs only gave 2 days notice before bringing the lawsuit. And as Judge Contreras noted in his opinion, you can't cure that. So Dr. Bronner's ability to bring a derivative claim was dead on arrival, even if the bylaws had never been amended. I wanted to correct the record on those 2 points, and then I will cede to Ms. LaHood.
Thank you. Ms. LaHood?
Thank you, Your Honors. I have several points, not necessarily in order. I mean, first, as to what a claim is, the claim is defined as the DC Council defined it, not as Mr. Marcus would like it defined. His claims about why Ms. Gordon was dropped from the case, they're not in the record. They don't have to sue the hundreds of people that were in favor of the resolution in order to be targeting, but it doesn't even matter because targeting isn't the question. It's again about the various acts. They say that they claim that they sued the people who did the acts, but They don't actually say who did any of these particular acts. The one claim, I mean, Mr. Marcus conceded that writing an editorial would be something that would fall under the Anti-SLAPP Act, which is what Professor or Dr. Slida is accused of. They didn't say what, he didn't say one other thing that Dr. Slida or any other defendant did that would fall under the Anti-SLAPP Act, except putting your hands in the cookie jar and approving that. He mentioned the bylaw amendment that, again, would have permitted funding the litigation, that they didn't notify the membership. In the bylaws, which are attached to the complaint, Article 13, Section 1 says they don't have to notify the membership about amending the bylaws. That's not a claim. That's not even a factual, it doesn't matter. He also says the claims were about more than funding the litigation. They weren't. If you look at
Ms. LaHood, before you go on for too long, can you just articulate what you would have us adopt as a test for what claims arise out of an act in furtherance of advocacy? But what would we say? What's the dividing line?
I mean, I'm not sure I can say more than I said before on this. I mean, here, I would say that this entire complaint arises out of the boycott resolution, which falls under the Anti-SLAPP Act. If that seems too broad to this court.
No, I mean, I appreciate that you would say that about this case. What I'm wondering is what rule would we announce that could be fairly applied by trial courts in future cases?
I mean, I think the rule should track the statute, Your Honor. I think.
But the statute is horribly ambiguous about what arises from means. And I think you've gotten the sense that all three of us have different views, maybe different views than what we had 2 hours ago on that question. So I'm asking, what would we say? And I'm not getting a lot of guidance.
I think looking to Algernon, as you mentioned, to show that it should be broadly interpreted, that it needs to be something that's, you know, it's a predicate. Without the boycott resolution, this case would not have happened. And that is clearly true in this case. It arose,
a but-for cause is what you're looking for.
I guess that's
right. I mean, Mr. Marcus
was.
has articulated a very specific standard saying it has to be about speech, right? Doesn't matter the nature of the claim, right? Could be a breach of fiduciary duty claim, right? But it has to be about speech. And you're saying speech is the but-for cause?
I'm saying the same thing. It's how broadly you look at it. Of course, it has to be about speech. First of all, Mr. Marcus is wrong about the legislative history in the ACLU, but we do not dispute that it has to be based on speech or expression or expressive conduct as defined in the statute. It doesn't mean that every single, you know, thing that's mentioned. Again, Mr. Marcus didn't mention one single act that isn't speech that makes up the basis of his complaint. Nothing. He didn't mention one. He said putting your hands in the
not respecting the vote, treating the resolution as having passed when it failed to get 2/3 vote. Like
so that claim is not against Dr. Salida, and it is a statute of limitations problem, and I'm dealing with all the ones that are actually.
But assume, okay. I mean, it just seems like you're kind of not helping us draw lines. So
I think if you look to the actual, if you look at the breakdown, the elements of a claim and the factual allegations that support them, I think, you know, I think what the California court has done is actually struck all factual allegations that fall under the statute. So anything that is, you know, speech or expressive conduct that would support this, and I think that's what they've done.
Can you give an example of an allegation in the complaint here that you would say the California Supreme Court would strike because it's about speech or whatever test they apply?
I think every single allegation should be struck because it's about speech, because again, I haven't heard what's not about speech. I guess there was the example you just gave, which was, again, I'm sorry, it's not an account I've dealt with, but about, and you know, I feel like we're going back to the same argument, but it is in connection with an issue of public interest. It's in connection with the policy dispute about Palestine and Israel, right? I think was the question, I'm sorry, was the question about
Well, that's
not
what,
sharing
that's,
information.
okay, I mean, that's a very broad definition then. You're saying that any cause of action that has a connection with an act of speech is fair game for the anti-SLAPP motion to dismiss.
Not
That's-
even just
I'm
about
saying-
speech, but about a public policy debate writ large.
As I've said, the statute has to apply. The factual allegations underlying the claims, if they fall under the Anti-SLAPP Act, it applies. So I'm trying hard to think of something in the complaint where it would not apply. Because the allegations against the defendants are, again, I just gave the amended the bylaws. Okay, maybe, I don't know, amending bylaws generally might not fall under. Here, the allegation is that they amended bylaws so that they could take out money to fund litigation.
And my reaction to that, Ms. LaHood, that's a good example, because the problem I have, and I want you to address it, is that it may be the case that amending bylaws to enable yourselves to fund litigation is protected by the First Amendment or is speech in some sense, but that is not an act of public, it does not fall within the definition that the statute gives of an act of public advocacy. And that is my concern here. I read that definition as applying, the only thing that definition applies to in this case that I'm aware of and that I thought was being argued was the resolution. And so a claim based on falsity in the resolution or misuse of the resolution in some sense, or the speaker didn't have the authority to declare that resolution. Those are claims I think I can see as arising from the resolution. But I don't know that the example you just gave of amending the bylaws in order to make funds available so that they could, issue the resolution and defend the resolution falls within that category.
Your Honor, it might be a close call. The thing is you can put lots of allegations that aren't material to the claim into the complaint. Here, amending the bylaws is immaterial because on the face of the complaint, they did not need to notify the membership. Again, Article 13, Section 1 of the bylaws. It's immaterial that they amended that they didn't notify the members. So what? They amended the complaint. It's not a material basis of the actual claim, whatever that claim that is, fiduciary duty breach or whatever they brought it under.
Well, they
So
may be
maybe
wrong.
the test is,
I mean, the claim may or may not have merit, but the question is different. The question is whether it is the kind of claim that is meant to be protected under the Anti-SLAPP Act.
it's a factual allegation to support a claim. And I guess what the court could suggest is that if you look to what are the factual allegations that support a claim, do those factual allegations fall under the Anti-SLAPP Act? If they do, the Anti-SLAPP, the act applies, and then you see, was there evidence to show that it's likely to move forward or not?
And again, that's why I asked you earlier, give me an example of a factual allegation in this complaint, a specific example of one that, I guess the words you use fall under the Anti-SLAPP Act.
That's what I gave previously, Your Honor. The ones, the funding of litigation falls under the Anti-SLAPP Act.
Okay, there I don't understand that, to be honest.
I'm also confused. It sounds like you're saying, okay, let's look at a claim and we don't have to look at the facts that are material to the claim. We look at the facts that aren't material to the claim, and those facts can make something an anti-SLAPP suit. Is that?
You look to whatever facts the plaintiffs allege support their claim. You may say, but that doesn't support the claim. So it's still an Anti-SLAPP Act just because the plaintiffs did a poor job showing, alleging things, the facts to support their claims doesn't bring it out from underneath the Anti-SLAPP Act. The factual allegations are speech or expressive conduct that fall under the Anti-SLAPP statute.
But they're non-material facts to their claim, right?
They can be material in order.
The plaintiffs are there saying this doesn't have anything to do with our claim. These are not material to proof of our claim. We're trying to show, you know, misuse of funds, breach of fiduciary duty. So the facts about the resolution are not material to our claim, but the non-material facts are what make this an anti-SLAPP in your view.
No, I think any facts, any alleged facts, before you even determine, could make it an anti-SLAPP issue, right? If whatever the claims are, like here, if the underlying facts are brought under the Anti-SLAPP Act because they're speech or expressive conduct, and the Anti-SLAPP Act applies. What I'm saying is you can't say, but the complaint also alleges that their car is blue, to go back to the car example, and that's not an act. The Anti-SLAPP Act doesn't apply. It's immaterial if their car is blue, just like it's immaterial if they amended the bylaws. So I think there has to be, you know, if you put in a 200-page complaint, again, I haven't heard one example, and this is maybe a better question for, you know, for Mr. Marcus, what are the acts that they are alleging were done by the defendants that actually underlie their claims? If I may say, he said that there were other acts. He didn't say what they were, like, or the litigation, the fund, the withdrawal of the funds could be used for something other than litigation. Those things, as stated in the complaint, which are all barred by the statute of limitations, but were for a new website, which was not resolution related, so it has nothing to do with it. A media strategist and PR consultant, those are things to put out, you know, statements about the resolution, so that falls under the Anti-SLAPP Act. And then arguably for payments around a meeting. They don't even allege they were for payments around a meeting, they don't know. The other expenditure they said was that the executive committee approved directors and officers insurance. So that's somehow related. Is it related because plaintiffs sued defendants and then they wanted to get D&O insurance? You can't just say there are above acts that are alleged that don't fall under the Anti-SLAPP Act without actually saying what they are. And that's the analysis that should have been done. As to Judge Deal's question about did we raise whether there was evidence? Yes, and on pages 14 or 15 of our appellate reply, we say all the places below that we did. And in each of our replies, we mentioned it, and an oral argument, it's in the transcript, and those sites are there. And I believe we did argue that why each claim should be dismissed claim by claim. So I'm not sure how to respond to that. Back to the question, and I don't know, maybe we've already discussed it enough, but the statute of limitations example. First of all, you know, yes, Judge Deal is right. The court can refrain from awarding fees if it's unjust. But again, the statute of limitations is an affirmative defense under Rule 8, and Mann says that winning on the merits includes as defenses. Here, I just want to say that the ASA resolution was passed in 2013. Plaintiffs didn't bring suit until 2016. That was after the DC Circuit decided that the Anti-SLAPP Act didn't apply in federal court. So it was their choice of forum to go to the federal court. I understand procedural arguments might not fall under the Anti-SLAPP Act. That's why we didn't, frankly, appeal the personal jurisdiction argument by Judge Rigsby, which was wrong, but I think probably could be considered procedural. I think everyone knows that the 12b6 motion is not appealable, and we're not arguing that. I think everyone understands that. The First Amendment right to petition point, the DC Council balanced that right with the First Amendment right to speak out on an issue of public interest, and the court in Mann upheld the statute's confidentiality. The plaintiffs have the burden here of providing evidence, and on the first prong, it is not onerous, as several courts have found. Just to repeat again, the purpose of the Anti-SLAPP Act, it's to fend off suits exactly like this one, exactly where one side is trying to punish the other side in a public policy debate, even if they can come up with 100 and whatever pages of supposed allegations, but when you get to their core, the core of the allegations, the actual facts, they fall under the Anti-SLAPP Act. They should be dismissed. Thank you, Your Honor.
Okay, thank you. Mr. Kleiman, are you batting cleanup here or no? Okay, you're muted, so we can't hear you. You're still muted, so we can't hear you.
Yeah.
You don't know how.
He's
not talking.
Well, we will take the case as submitted. And thank you all for a very interesting and extensive argument. You are excused, and you may log off.
Thank you.
This
Your Honor.
honorable court is now adjourned.